Yes, so thank you. Welcome to day 3 of the class. So we're going to discuss online mediation or technology mediated dispute resolution, which our focus will be. There are a lot of technology dispute resolution mechanism, but we are focusing ourselves on mediation as a way of resolving dispute without meeting people physically, without also meeting in a physical space, but you can meet in a virtual space where you can assist the parties to resolve such matters. And when we are talking about technology mediated settlement, we are not only looking at um, certain online platforms alone, but they can also be even phone conversation. I remember I did a mediation through phone call. I think I've done 2 mediations, two with phone calls. The only time we met was the one party who brought the issue. They came and they said, well, I called the other party. The other party is incapacitated and cannot come to the office. So if we can have another way. So what we did, was call the other party and inform me that this is what your other person is saying, and if you are comfortable with us having the meeting on um, phone conversation, are you comfortable with that? And they said yes. So I started with online through phone. So I called them. I don't want them to call me. I will call them. So I call this one, I call that one. Then I put them on conference call. Then I'll be speaking with them. So I put on the ground rules, everything. Then they agreed, and we started the discussion. So once the discussion is completed, I asked the one who brought the issue to come. So I put the settlement together, together with the consent bill, and gave it to him so that they will all go and sign. So they went, signed. I didn't sign my part because I wanted them to go and sign their part. This is because if I sign my part, the person going can go and change something in maybe one of the documents and say that I have already signed and the other party should sign, which the other party may not agree. So what I did was I did the document and I asked him to go and see the other party. They should sign. And when they finish signing, they should come back to me and I'll sign my part. So they brought the document back. I look at what I've given them, compare with what I had already, and I realized that it's the same document. So now I appended my signature and I called the other party that did he bring in the document to sign? He said yes. Then I now hand over the document to the person who brought the issue and ask him to go and deliver one of the document to the other party. So that is what brought an end to the issue that they were having. There was another instance where I have to whether there was two acrimony and meeting them physically will not be worthwhile. So I spoke with them, I discussed with them. So what I did was that I created a WhatsApp page for the two of them. I put the consent to mediate there. They looked through and they accepted it. Then I called them on phone for us to talk. I think I called them 4 times and we were able to do the conversation and completed the mediation. They had the agreement. So I did a draft settlement and I put it on the WhatsApp. They said it is okay. So I met them. This time I met the two. They were people who can move. So now that the agreement and everything has been sorted, I met them physically where I showed them the document. They now signed to the document, and I gave each one a copy of the document, and that ends the matter. So this is how you can also use technology, not only about online platforms, but using phones and other platforms to do mediation to assist individuals who are in this. When sometimes there are certain issues that it will be better to engage them online rather than bringing them into a physical space, which may bring a lot of issues. So that is what I did, explaining and bringing it to fore with what we are doing today. So according to David Allen Lawson in his article, Technology Mediated Dispute Resolution, TMDR, so he said opportunities and dangers. He indicated that technology mediated dispute settlement is not new. So he said, in fact, we have been engaged in technology-mediated dispute resolution throughout our careers. We use telephones, fast line machines, email messagings, and we continue to add new technologies to our dispute resolution practices. So as the name suggests, technology-mediated dispute resolution simply describe dispute resolution processes that use technologies to facilitate communication and information exchange. So, mediation is about facilitating communication and also information exchange. And if communication will help us to do that, then we use it to do that in order to help disputing parties to resolve their issues. So, what then is online dispute resolution? So online dispute resolution, as you hear online, ODR, it is something that is so evolving. It is often referred to as ADR, which takes advantage of speed and convenience of the internet and ICT. So ADR is best and often the only option for exchanging redress of consumer grievances, strengthening their trust in markets, and promoting sustainable growth of e-commerce and other cross-border dispute resolution. For instance, you bought a product from Alibaba, you bought a product from eBay, you bought a product from, maybe you have a Visa card. You may not have a Visa office within your country, but if you have a dispute with them, you can use online mechanism to resolve the same so that your matter can be addressed. And also, e-commerce platforms have mediation aspect within their platforms that they use to resolve. So evolution of online mediation. So this is how it is. Yes, the mediator, the parties in different, in their offices, in their homes, wherever they find themselves, they can be engaged virtually. So online mediation is subset. So online mediation is one aspect of technology mediated dispute resolution, has emerged to advancement in technology and the need for more accessible, more accessible dispute resolution method. This evolution has been accelerated by factors such as globalization, the proliferation of digital communication tools, and COVID-19 pandemic, which necessitated remote interactions. So although things were happening, but COVID fast line most of the things that we or fast track most of the online interactions that we find ourselves in today. So online mediation offers benefits such as accessibility, reduced cost, and convenience, making it popular choice for parties in different geographical locations. It's the same way that we are doing this course. I am in my office in Ghana, and we have people from Zambia, we have people from Kenya, we have people from Nigeria, and joining from different time zones and other from other places. So this is what makes technology more useful. And for instance, if you have a mediation and you have to use online to do it, that doesn't matter. You don't need to drive through the traffic. You don't need to move. You can sit in your office. The mediator will also be in their office, and they will do the mediation. I remember last 2 weeks we did. We do dispute resolution as well. So sometimes some of the meetings you have to do preliminary meeting with the parties to align what they meant by their dispute resolution clause so that the process can commence. And through that, this matters. You don't need them to move a car to come to your office. You can have this matter dealt with online, and makes it more simpler and easy. The same way mediation is made, online mediation making. So how online mediation works? So online mediation component. So the mediator, a neutral facilitator who help the parties reach a resolution. Then we have parties involved in dispute and seeking to resolve their dispute. Then we have the technology. So you have this four entities coming together. So you have the mediator on one side, the parties. So the parties, the disputants, the two parties. Then you have the technology. So mediator, parties, technology. So you need these three things to bring the fold together in order to do the technology mediation. So the technology platform tools and platform like the video conferencing platforms and document sharing and digital signature facilitates the process. So all these technologies that allows you to do the online mediation. So online platform that allows you to be able to do this. We have WhatsApp. WhatsApp, you can use WhatsApp, you can use WhatsApp video, WhatsApp call to do this, and you can use it to share document with the parties as well and make it easy for you to communicate and have the matter resolved. Schedule meetings, and you can even schedule meeting with the online with WhatsApp. We can schedule and create a link for meetings and other things. Then we have Google Meet. Google Meet is also there to have help parties to do that. We have phone case, we have Telegram, we have Facebook Messenger, we have Zoom, Teams. Then we have organizations that have designed specially designed tools or conference tools. So they are organizations that have all developed their own platform that they use to do their own mediation and other platforms. So there are other numerous platforms that you can use that have not been listed here. So steps in online mediation. So initiation, that is the initial contact and agreement to mediate online. So who brings the issue? So you bring one party brings the issue, the mediator gets in touch or the center gets in touch with the other party. Parties now meet online and agree that they want to do the mediation online. So if you want to do the mediation online, selection of a suitable online platform. So which online platform will be more suitable for all of us to use? So do we use Zoom? Do we use Google Meet, or which platform do we use? Then the parties will decide. Then scheduling of session. Now they will schedule the session, the date, agree on the date that they want to meet, whether after work or before work or what time or weekend, which time that all of us will have a convenience to do. Then mediation session conducted through video conferencing or audio conferencing, depending on what the parties desire. Then resolution and drafting of an agreement. So once you are doing it, so if it is Zoom, I can integrate, I can show maybe Word whereby I'll be typing the outcomes and the parties can be able to read. And once I finish typing, I share with the parties and they can add their digital signatures. There are platforms that have digital signatures that you can subscribe to, where parties can sign their signature there, or where parties, if they trust the mediator, they can sign their signature and send it digitally to the mediator. Then the mediator will fuse it into the document, convert the document into PDF document, and share with the parties. These are all available ways that parties can use, and you, the mediator, should understand this to be able to assist your parties and the individuals that come to you for various services in mediation. So it is not always that they have to come to your office and meet you, but they can be meeting online and you can access them. So you can decide then the agreement, then distribution of the signed agreement, whether you have a WhatsApp page for them or you can send it via email and they will have it. Then compliance. As for compliance, once you are done, the rest of the compliance, it takes effect the same way the other physical mediation takes effect. The mediator's work is done. The parties have to do their own enforcement. Then let me also say that laws, the majority of the mediation laws recognize the use of online platform for the mediation. Because if you look at even the Ghanaian law, it accepts with the initiation and everything, where you can do telephone, fax, and other things. So online mediation is accepted under the Ghanaian law, so you can use it and it is acceptable and enforceable. So advantage of online mediation, it is flexible, the flexibility of it. The parties can schedule session at convenient times and from any location. So this one will not be like, I have traveled and I'm not around, we cannot meet. No, any location, wherever you are. The most important thing is have access to a device which can have internet. So once you have access to device which can have internet, um, you can now meet online for the various discussions. Any question up to this stage?
Um, I'm just thinking of the carcass, other platforms such as Zoom
Yes,
can
so good. It's good that you have brought that up. Yes. So other platforms such as Zoom, for instance, we have Zoom here. We are using Zoom for the training. So if you want to go into caucus, and what you do is that you create breakout rooms. So you will see that if I want to create a breakout rooms, I can create breakout rooms. So what you do is that you assign the people manually. You don't create it and assign them automatically. So the moment you create it, open all rooms. So you see that there is an open rooms on your screen. Have you seen that I've opened a room on your screen? Yes. So I can decide to
Yes.
assign I can decide to assign members to that group. But when I assign, you don't join. So maybe Christine, I can send you to room one. I can send um, Gloria. Then I send you to assign you to room two. But when I assign you, don't join. Uh-huh. So these are ways to assign them. Ways to assign them. So you'll be assigning them to those rooms. So once you assign them to the room, so I can just close the room. I was telling them not to join, but they joined. Oh, okay. Welcome back. Those who joined the platform, welcome back. I said don't join, but you joined. So that is how you can create rooms for caucusing purposes. So you create the room, then you assign them to the room so that they join the room. You go there and you interact with them. Then you go to the other room and you interact with the other person. Then you close the room and bring all of them back into the main session. Then you continue the discussion. You see how easy it is, simple, so that you can do it, right? So it is flexible, so it makes it flexible and you can schedule from any location. Cost saving, reduce travel expenses and time away from work. So if the work you are at work and you have to do mediation online, you can take your a time off instead of traveling. That time can be used for the mediation and the work can continue. And accessibility enable participants from different geographical locations to meet. So you can be doing mediation with somebody you have issues with at Kumasi, at Accra, at Kenya, in Kenya, in Togo, in wherever you find yourself, it doesn't matter. Then it's a comfort and convenience, allows parties to engage in the process from familiar environment. So you sit in your own office and talk to the people, right? Then challenges and limitations. So technology issues, connectivity problems, and varying levels of digital literacy can hinder the process. So sometimes you are dealing with someone who don't even understand how to use Zoom, how to use Google, how to even use WhatsApp is a problem. So it makes it difficult for such people to be able to access those platforms. So those are the challenges that we encounter sometimes if you want to use technology, online mediation, if you want to do online mediation, because the person at the other end may not understand these platforms. But as we grow and generations are coming, a lot of people are getting to know Zoom, getting to understand Zoom, they're getting to understand platform, and it will be easy to apply this method. And especially when you get commercial matters, you are good to go, you don't have issues. Then security and confidentiality, ensuring data protection and preventing unauthorized access are critical. So sometimes security and confidentiality. Sometimes the only difficult aspect is that you don't know who is behind the person talking to you, who is at the end of the call talking. So that may pose a challenge. Then communication limitation, the lack of in-person interaction can reduce the effectiveness of non-verbal communication. Sometimes to meeting the people, emotional attachment and can help in resolving the matter faster. Sometimes, so you may not get that intimate connection. So, for instance, if you are we're supposed to be at one place, the feeling and the discussion will be different from we being online. Although we can do everything, but the interactions and the connections that the bond may not be there since we are meeting online. Yeah, so that is the only difference that can happen. The legal and regulatory challenge, jurisdictional issues and enforceability of online agreement pose challenge. So some jurisdictions may not recognize online agreements. So you look at your jurisdictions and what the law says. The legal and ethical consideration, compliance with data protection law. So if you are using online platform for mediation, you have to ensure that you adhere to regulations like general data protection law. Then confidentiality and impartiality. Mediator must maintain confidentiality and impartiality in an online. Mediator too, you don't go and sit somewhere people will be listening in the conversation. Since the parties are not there to see, you'll be there and people will be there to listen to what is happening. So it is important for you to also respect that as well. Then drafting enforceable agreement, clear and legally sound agreement are essential for enforceability. So once it doesn't matter whether you're doing it online or physical, you have to ensure that you draft proper agreement that is useful. So future trend in technology mediated dispute solution, artificial intelligence and machine learning. Now LLMs are everywhere. Machine learning is everywhere. There are a lot of platform um, that you can use. So AI can assist in data analysis, predict outcomes, and also provide insight during mediation. So you don't need the AI cannot tell you what is in the minds of the individual that are coming for the mediation, but you can narrate the issues, and the AI can predict some of the things that you can look out for, some of the conciliatory gesture, or some of the uh, questions, open-ended questions that you can ask during the mediation. It will help you to generate that, and you can use it for your mediation. So advanced platform, more sophisticated and secure online platform are being developed to enhance the mediation process. The, the virtual and augmented reality. This technology could provide immersive environment for this resolution. The institutionalization, increasing recognition and formalization of online mediation in legal system. And when you look at, there's a platform called mediate.com where they are integrating a lot of online ways of doing mediation. So mediate.com, 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 you can check it out. It has a lot of things that are going on there. Right. So the use of AI in mediation, so blockchain for mediation process and case tracking. So You can use AI in mediation, but it can help you to do blockchain, maybe tracking your case, maybe your AI will help you to track your cases and make sure that you receive this case. This is the process it has gotten to this end. Then insight generation for effective mediation. You can use it to do insight generation. You can interact with the AI. It will give you insight ideas. Then virtual platforms. You can also use AI to create virtual platforms for mediation. Then language translation and AI assistant. So AI tools are also being developed to do virtual translation. Instead of having individuals at the booth to do the translation, the AI can help you to translate the languages that the people may speak, which you may not understand, so that it will help. Then decision support system and creative problem solving. Then educational tools and training. So AI can also serve as educational tool, help you to for training and drafting of settlement for editing. So AI can help you. So for instance, Meta AI, everyone has Meta AI on their phone. So you can click on the audio button. Now Meta ChatGPT also has majority of the AI platform has an audio button. So if you cannot even type, narrate what has happened in the mediation and ask it to give you a draft terms of settlement. So we can all even try it here. So when I finish this, remind me, we'll try it here. We'll narrate an issue and we see. Right. So thank you. And yes, so this is what brings us to the end of the technology mediated. We will continue with our other classes. So let's try with the platform. We have about the next class supposed to start at 11:30. So it's now we have 30 minutes. So let's try our hands on with the AI that I was talking about. So this is it. So you can use it to, I hope you can see the screen. Hello, are we there?
Yes, please. We can see.
Okay. So if you can see the screen. So assuming we we have a discussion, we have had a discussion. So like the video that we watch, for instance. So the moment I come here, I can just click here and detect. So I just click on this. So I have to allow while visiting this site. So um, Jack and Beck came for mediation relating to a lawn that Jack mowed in front of Beck's house, which has a significant meaning to him as a remembrance to his wife. So at the end of the mediation, both parties, having gone through the mediation and having had a successful discussion, have agreed that they will be good neighbors. And also, next time, before Jack will do something like that, he will go and discuss with Beck and whether he can weed in front of or clear his lawns for him. And this has been a successful mediation, and they have even agreed that Beck will come and visit so that they can have a dinner together and use this to draft terms of settlement, taking into consideration the context to which they have agreed upon, and also the good neighborliness that they want to achieve and for the good relationship for the future. So draft terms of settlement as an outcome of their mediation. So the moment you finish, you just type. So you see it has brought what I was saying. So this is it. This is what I was saying. So the moment I click here, it is now going to type the terms of settlement. So you see, it has typed the terms of settlement for me based on the detection that I gave you. So he said this term of settlement is made following a successful mediation between Jack and Beck concerning the clearing and mowing of a lawn area in front of Beck's residence. So parties Jack and parties to this settlement are Jack and Beck, collectively referred as the parties. Background: a misunderstanding arose between the parties after Jack cleared mowed lawns area situated in front of Beck's house. During the mediation process, Jack explained that the lawn held significant sentimental value as it served as the remembrance and connected to his late wife. The parties participated in mediation in good faith and reached an amicable resolution at aim at preserving peace, mutual respect, and good neighborly relationship. Agreement reached. The parties hereby agree as follows: good neighborliness. The parties agree to maintain cordial, respectful, and peaceful relationship as neighbors and to communicate openly and respectfully regarding any concerns, any concerns that may arise in the future. Then, prior consultation, Jack agrees that before carrying out any future clearing, mowing, weeding, or maintenance activity affecting the lawn area in front of Beck's wasteland, he shall first discuss the matter with Beck and obtain his consent. So give me a second. Yes, sorry. So mutual respect. Beck acknowledges that explanation regarding the sentimental importance. So these are what the AI has done for you. So your own is to bring this. So you see that signed by the parties on this day. So Jack, Beck, it is up to you to pick this and develop it into suit how your law recognize ADR outcomes. So you don't just copy this and paste it and print it for them. Pick this, edit it, and to suit how the format is supposed to be based on your country or your law. So that in the event of enforceability, it can be enforced. You don't just pick this and go and put it anywhere. Right. So that is the example that I wanted to show you. Any question? Any question up to this stage? Any question? Contribution, additions?
Sorry, which app was used?
Chat GTP.
All right, thank you.
Chat GPT. Yes. Okay. Okay. Any other comment from anyone? Okay. All right. Pakwesi, are you ready? If you are ready, you can take it from here. Hello, Paul. Paul, can you hear me? Hello, Paul. Hello, Paul. Okay, so let's give ourselves 5 minutes break where I get um Paul to take over.
Okay, so in a moment, let me share my slide. Predo.
Yes, I can see. You can go to slideshow mode and continue.
Okay. So thank you. So my name is Paul Akwesibari, and then today we'll be discussing handling power imbalance in mediation process. So our objectives, this will be our outline, presentation outline. We'll look at the objectives and all that. So by the end of this session, participants or we would be able to, one, identify multiple sources and forms of power imbalance in mediation process. Apply practical mediator strategies to address structural, cultural, and institutional power disparities. Navigate ethical tensions when balancing power autonomy with the imperative process of fairness. So also look at the we also develop a personal action plan for addressing power imbalances in mediation practice. So as we watch the video, we observe some power issues that in my area statement, I mentioned them. So when they started, the man said he has lived there for 45 years. He referred to the other party as a kid. So automatically, he has some preconceptions that if he considers his age and the number of years he has lived in the area, and then you just a kid, you just came, and you want to come and mow my roses without even coming to introduce yourself to me. So you realize that when they met on the mediation table, everything showed. He didn't mention his first name, he mentioned a kid. And he started trying to, show his scratchy powers there. So power in this context is the ability to influence events or outcomes. Referring back to the video we watched, amongst all of them, including the mediators, the man was the oldest. So in our African culture, if you meet on a table and the elderly person is there, naturally he or she feels that he has the power to influence whatever happens on the table. And it is not different when it comes to mediation table. But as a mediator, you have to be aware of all these power imbalances, and then you try to act professionally. So power imbalance occurs in mediation process when one party can unduly influence the process, the outcomes of the mediation, and all the behaviors or all the activities that will happen in the mediation room. As a mediator, you are required to identify the power that each party holds and how that might influence the process. Oh, okay. Can you still see my slide?
No, can you project it again?
Oh, okay. Sorry, something happening. Can you see it now? No. Okay. I hope you can see it now.
Yes.
Hello.
Yes, it is visible now.
Oh, all right. Yes. So, understanding power imbalance in mediation. During conflict, there is often an escalation period. If we send our minds back to the video we watched earlier, When Beth realized that Jones has mowed his roses, he went to his door and then he started shouting. That was the escalation period. They were all shouting. Maybe they are shouting at themselves. Nobody was ready to listen at the moment. So sometimes there is an escalation. During the escalation period, parties often try to use power to achieve the outcome they want. So sometimes they feel like when you shout on the top of your voice, that is when you be heard, or that is when you are able to influence the process. So in our African context, you realize that somebody will say, "Do you know me? Do you know the person you are talking to? Do you know the person you are trying to maybe disrespect or maybe have an issue with?" A party might take an entrenched position. I won't agree. I will not understand. Trying to exhibit some kind of control. They are all part of the power we are talking about. The use of power to force the other party to comply is rarely successful. So it doesn't normally end well. So they are not able to arrive at a common agreement. As a mediator, you need to be aware and use skills to help the parties move away from their positions. So they have their own positions, and the interest itself is there. So if we still send our minds back to the video, the old man said he needs an apology. Then the young man said he also needs an apology. When they went for the caucusing, you realize that the young man cleared the roses because he was going to have his party. And then the man also said the roses are linked to his late wife. And you see, they all have the interest. But the man also said, when you came, you didn't even introduce yourself to me. You didn't introduce yourself to me might be a position. But the main interest is that you have taken away his joy. And the joy here is the roses you have created that he normally used to remember the late wife. So as a mediator, you have to focus on the interest. Now, types of power in the mediation room. We have the structural and then the institutional power. The structural or institutional power, we have positional, hierarchical authority. So, for example, CEO versus employee, government versus a citizen. You realize that the power level is not the same. There's normally a vast difference between the two parties. For example, a father and then a son, they have an issue, and you, the mediator, you send them to the mediation table. You realize that naturally the son will not feel that he has a power equivalent to that of his father, and it continues like that. So institutional backing. So if you have an issue with, let's say, an MTN is not providing the services you want, then you want to go to the mediation table. Maybe you realize that it's a corporate entity, and you, with your resources, if you compare your resources with that of MTN, you realize that you don't have a power like that of the corporate entity. So you see that there will be vast difference. Control over implementation of any agreement reached. There are some parties who have a major control over some of the agreement. For example, a father and a son has an issue. Then you mediate, they agree on maybe settlement. Then they go back to the house. The son is still dependent on the father in the house. So you realize that when the implementation of the settlement comes, the father has more control over the son. Maybe that at that time the mediator will not be there, but the son too may not want to go back to maybe the mediation table again. Then access to partner, that's ability to walk away without consequence. And then best alternative, maybe the person has another alternative direction to go or to consult. Maybe after the mediation process, we'll be talking much into it when we get to some of the slides. So we have relational and then informal power. The informal asymmetry, here, one party knows more about the fact, the law, and the process. So you go to the mediation table and maybe the crime or the offense or the issue you are dealing with, somebody has more information about it. The person has more fact. The person understands the whole process more than you. Automatically, you become vulnerable to the person, the party, the other party. Social capital. We have networks, alliances, reputation, and in the community. So you are in the community and you have an issue, let's say with the assembly member. And if you compare your influence to that of the assembly member, you realize that your influence is not equal. So when you go to the mediation table, the way the mediator may handle the issue, if the person is not professional, the person will be carried away by the influence of maybe the assembly member in the community. Emotional power, ability to withstand stress versus vulnerable party. So there are some people, they declare themselves as litigants. If it will take several years, they will still follow the case. Some people too may not be able to follow through cases. They say, I don't want to stress myself, so I will take the weaker side stance, or I will just agree to it so that we end the process. It can also happen. Then cultural authority. Somebody talking. Hello. Gloria.
Sorry.
Okay. All right. I hope you can still see my screen. President. Hello, can you all see my slide?
Yes, it's clear.
Oh, all right. Okay, thank you. So the cultural authority, elders, religious leaders, traditional chiefs. So if you have a problem with the elders of the community, then you go to the mediation table, you realize that you don't have the same power in the community, and you may carry that differences to the mediation table. Religious leaders. In Africa, we cherish our religious leaders very well. So if you have an issue with them and you go to the mediation table and you are the mediator and you don't apply all your professional skills, you will end up siding with maybe the religious leader or trying to the other party trying to take the weaker stance. Gendered power dynamics, especially in our family and land dispute. Women and men in our African context do not hold the same power when it comes to land dispute. So a woman and a man goes to the mediation table to seek for maybe settlement on issues related to land. You realize that the power on the mediation table as far as the parties are concerned, are not the same. Now, let's reflect on this. Let's think about a mediation or any issue you have observed in your community or you have participated in, and try to identify some of the sources. So let's apply the video we watch. Let's apply that here. What are some of the power issues we observed in the video we watched earlier this morning? Like the types of power they exhibited. Hello.
I think one of the powers was around age.
I'm around, sir. Look.
Yes, Josephine. Age. One was age.
One of it was about age. In the normal human age, there were two ages here, and
Yes.
the residence age, because
Yes.
he seems to have some authority around that area, owing to the fact that he's been there for quite more than 4 decades, and here is just a person who stayed a few days and wants to interfere with his joy. So there are two levels of age: residency age and the generational difference.
Yes. Any other observation from colleagues? Okay. So thank you very much, Josephine. And you also observe that the old man knows the history of the area more than the young man that just moved in. Is that correct?
Yes.
So he talks about he had other neighbors. Whenever they came to greet him. They came to introduce themselves to him. They never complained about the roses. And you, young man who has no idea what is happening in the area, you came and you have started clearing them. So that is also other aspect. And culturally, because he didn't even go to greet him or introduce himself to him, meant that he doesn't respect him or he has offended him in a way. That is how the old man took it. Okay. So types and sources of power in African context. Now we are coming to go into details of the Bartner asymmetry, a critical power lever in mediation. The Bartner, a best alternative to a negotiated agreement, is a party's most favorable course of action if negotiations fail and an agreement cannot be reached. There are some people, they have plan B. So before they even go to the mediation table, the person has already told himself that if the mediation process fails, maybe I will take litigation, I will go to court. Now, a lot of factors will make somebody think that way. Maybe one, the person feels that he has the resources to go the litigation way or to seek for justice in other areas of justice delivery. So the person already has an alternative to the negotiated agreement. If this one doesn't work, then I will go to the other one. Now, the Bartner issue is arguably the single most important determinant power at the mediation table. A party with a strong partner, for example, somebody's phone is ringing.
Yes, sir.
Okay.
Yes, I've had a question.
Yes.
A question.
Yes.
Like,
Go ahead.
yes, if two parties are coming on the mediation table and one have it in mind that no matter the mediation goes and it doesn't favor me, I'll still go to court. A situation where these parties to both have gone to court, but it has not also favored another party. And can this other party that thinks the court has not been favored him should bring it on mediation table? Can that be possible?
Yeah. So there have been instances that you go to court and then court will look at the relationships and refer you to the mediation table. And then there are other times you go to the mediation table and it will end on deadlocks, like deadlocks. You are not able to agree on settlement, and the person will still want to move on with other channels of seeking justice or settlement.
Okay.
Is that okay? Yes.
Yeah, a top-up, a follow-up.
Yes, please go ahead.
Okay. Where two brothers are coming from the same lineage, the same cultural background, but just a leadership role. One thought, oh, after all, you are my brother. You can be a leader over us. Never thought that one day it could use against him that you neglected that, and I took it upon myself to rule. So in this situation, it is mine. This case, how will you handle it? Will you advise for it goes back to court when court has not even finished, maybe from the regional, what is it? From regional court to appeal court, now it is Supreme Court. With this case, how will you advise? What advice will you give to this family?
You see, with the issue of conflict, you know, the concept of conflict is so complex. We have resolution, we have management, and a whole lot. So you see, there is always the opportunity to appeal. So you have gone to one court and the court ruled and you are not happy. There is an opportunity for you to move to maybe a higher court or an appeal court. And it goes up in that direction up till you get to maybe Supreme Court. And when you go to the mediation table and you are not able to reach on any agreement, you still have other channels of resolving the conflict. I don't know if I'm trying to answer the question you're asking, but it's complex, especially when it has to do with chieftaincy issues and all that. There are some conflicts that are protracted that we can't resolve. You only manage them. And there are other conflicts that can be resolved. So some conflicts are tied to values, like your previous lessons you have gone through, types of conflict and all that. Doc, is that okay? You can't say the person should not go ahead. Doc, come again.
Okay, for what you have explained so far, I've gotten you, but let me come clearly. Okay,
Yes.
let's say it's a chieftaincy, and you know, let me cite an example using the northern sector. The northern sector We have clients. We are being settled according to clients, and each client has gates. Each has client gates, and a particular gate, after inheriting a chieftaincy rule, then it goes to another gate because they are coming from one client. But this is a situation where another client said, okay, if that has been the norm of the northern sector, but for we don't want to be part of the client inheritance stage. It is only meant for one gate. In this situation, what will you do?
So there are structures when it comes to mediation in terms of conflict, chieftaincy conflict or dispute. So probably the traditional area has their own channel of handling those conflicts. Maybe they have the regional house of chiefs till you reach the national house of chiefs. So if it goes through that process and is not able to resolve, they might have had some settlement and some records. Any of the parties can still take the issue to court. And then the court will also have their own, in their own wisdom, also advise or also give some form of settlement. I know the northern region and some other part of the southern regions in Ghana is currently going through that. You can't conclude that once you have gone to the mediation table and there has been a sort of agreement there, the person has no right to move to other level of maybe seeking justice or addressing the issue. So I think it's a very sensitive area. So Doc, I think let's leave it here. But technically that is the explanation. The person has the opportunity to go further. Mr. Isaac, are you online? Mr. Isaac Asare. Okay, I think director is not online. So let's continue. Okay, so
Sorry, were you
the
calling me?
ability. Yes, there is an issue. I was thinking you can come in.
Okay, what's the issue about? Come again.
The issue is that, for example, there are some chieftaincy disputes in Ghana, and then sometimes they go to the mediation table, and it will look as if they have reached a settlement, and then few minutes later, then somebody will say, "No, I'm going to court. I will not agree. I don't understand the procedure or the processes that led to the settlement and all that. I don't agree to it." And doctor is asking that, is there any way to have a binding resolution on the person? Or doc, is that not what you are saying? Doc, hello.
Okay, so adding maybe from what you are saying, if I get the understanding, you want to know that maybe parties have gone through a mediation which involved chieftaincy matters, but at the end of the process, the parties are still against that and still want to go back to court. One thing is that
Yes.
no one can stop anyone from their legal right. But you have to understand that when it comes to chieftaincy matter, that is why the traditional council, regional house of chiefs, and the national house of chiefs was set up. So the issues have to go through those traditional council and the appellate jurisdiction. If the national house of chiefs is not able to complete the matter, the last stop is the Supreme Court. So any cause of matter affecting chieftaincy start from can start from the traditional can end up at the Supreme Court. So that is how the process goes on. But those are judicial processes. So there is a judicial committee under those councils that handle those matters. So once those judicial committees are available, they are empowered to handle such matters. So aside that, the parties can decide to go for mediation. There are some of them that are high stakes that parties can go for mediation. If parties go for mediation, one question we have to ask ourselves is that the outcome, did all the parties agree and accept the outcome to see and to say that this outcome reflects what we have agreed and what we have all understand the mediation process to be. That is where you can have any compelling outcome against any one of them. Because if they have agreed and signed to it, then it means that it becomes binding on them because you cannot appeal against the mediation outcome that you have agreed upon and sign against it. So once you sign and you agree on that, you cannot do anything about it because you have accepted it. You accepted the mediation outcome. You accepted, you voluntarily accepted, and you voluntarily signed. So that becomes the end of the mediation. But mediation, whereby there is verifiable terms of settlement, there is no verifiable outcome that to show that indeed the parties signed a particular outcome of the process. This is where it becomes problematic. Then the parties can say that we do not agree to this, we do not support this, and this is not what we agreed to do. And that is where the parties can raise issues relating to these matters. And this is important that if we are going into mediation, we should understand that mediation outcomes are for the parties. It is not the idea of the mediator. It is not how experienced the mediator is. It is not how we revered or respect the mediator in the space that we find ourselves. But the parties being able to choose the outcome that works for them and sign to it that indeed this is our outcome. Based on that, you can appeal against your outcome. You still have the legal right, but when you go to any court, once you agreed and signed the outcome and it is for you, then it means that the matter has ended. If not, we will continue to have this reoccurring of chieftaincy issue because the parties don't feel that the outcome belongs to them because they think that the outcome has been imposed on them. And these are some of the matters that we see around. So I think I have answered your question. Thank you.
Yes, thank you very much for the intervention. So, Doc, is that okay now?
Yes, Prof.
Yes.
Okay.
All right. All right. So, most of the issues we have been seeing around, they don't reach the settlement, then they go to court. All right. So, the partner asymmetry, we are continuing with that same concept. In African commercial disputes, for example, multinational corporations routinely hold stronger partner, as I explained earlier, I use the MTN as an example, than the local small and the medium enterprises. Government with limited legal budget. So if you have a multinational company in Ghana operating and has an issue with the state, you realize that government has to do a lot of things, a developmental project, and may not want to use chunk of its resources to go into litigation or go fighting for settlement and all that. So automatically the multinational company may have the resources at its disposal to push or forge on. The government may have the resources but may not prioritize fighting, using the resources to chase settlement and all that. And that is why you realize that in this, most of the African countries, we have issues with consumer rights. maybe service providers and then goods providers, they are not able to deliver to their standards, but the state may not want to take them on and be fighting them and all that. And these are some of the issues we are facing. What is the task of the mediator? As a mediator, if you are able to identify the power imbalances, your work is to help the weaker parties to understand, where possible, strengthen their partner through information and legal support before and then during the mediation. So you are trying to help the weaker party to also get to a certain level that there can be a kind of a balance. Now, let's compare. Somebody that has a stronger partner can litigate. The person has all the resources to seek justice everywhere. The weak partner cannot afford litigation. There has been instances in our community that rich person in the community and poor person in the community has an issue. Then the rich person says, if you don't understand, take me to court. And then the weak person, the poor person will say, no, what I will even use to take care of my children, I don't have. Why should I go to court? Then it will end there. The person has not gone to the court because he has no money or no resources. So you realize that the rich will continue to intimidate us. If you don't understand, let's meet at the court. Then your right will end there because you don't have what it takes to defend your right. Access to lawyers, representation even in the court is a problem. So people that has the resources has a stronger partner. Those who don't have the resources, they have weak partner. Financial resilience and all that. So it all has to do with the resources and what it takes to move on with other processes of settlement. Now, we have cultural power dynamics in Africa. So like we watch in the other video, elder or chief authority is always high. So traditional leaders hold enormous moral and social power. Example, a chief's endorsement can be more persuasive than any legal document. So you are going into a mediation and you realize that the chief in the community is in support of one of the party. If you are not a strong person and you have the moral judgment and then professional, you end up helping the one that has the stronger partner or the stronger support from the chief. Then we have the Ubuntu philosophy. I am because we are, collective harmony. So you have an issue in the community. Let's say you bought 4 plots of land in Otwinberiata community. Then the community says they want a community park. Maybe they want to use the recreational park for the community. Then they come to see you that this your land, we will compensate you and use it for the benefit of the community. Then you will say you don't agree. You go to the settlement table or the mediation room. You realize that if you are not careful, at the end of the day, they will look at the collective, how the park is going to benefit the community, and then settle on that. If the mediator is not skillful or is not professional, the mediator will be carried away by that philosophy of Ubuntu and say that, but they are coming to use the thing to benefit the whole community and you want to use it. They even said they will compensate you. So if you are not careful, you will side with the other party based on this philosophy. Gender and age hierarchy. Women and youth may be structurally excluded from speaking or having their interests represented in traditional processes. So there are some communities in Africa that you go and women are not allowed to talk. They are not allowed to express themselves. Children are not allowed to express themselves. When the elderly is talking, children cannot talk and all that. Can you hear me? My system is showing me some prompts that there's something wrong.
Go ahead.
All right. Thank you. Okay. The religious authority. In Ghana, we have the Islamic, the Christian, and then the traditional religious leaders. They hold power in our society. And this shapes what we can and then what we cannot be, we cannot say. So you go to the mediation table, there are some of the things you can only say it maybe during the private sessions. But during the joint session, you cannot say it because you feel it has something to do with religion or traditional or some kind of faith issue. You cannot say it unless you say it during the private session and all that. And there are also power structures that influence the mediation process. Let's go through this scenario. A mining company versus rural community land dispute. A multinational mining company acquires a concession to begin operations near a rural farming community in country X. The company offers a compensation and relocation packages to affected families. During mediation, the company arrives with lawyers, surveyors, and financial experts. The community relies mainly on elders and local opinion leaders. Many affected women and youth are not allowed to speak. The community people fear opposing the chief because he publicly supports the project. The company insists that delays will result in economic losses and threatens litigation if negotiation fails. So is it this scenario? Let's go to the discussion questions. Which forms of power are visibly and which are not visible? I think let me go back to the scenario and then we have time to go through it and then try to have a discussion based on these questions. So in a moment, let's go through it.
Increase is small. Mine is very tiny. I can't read.
You can't see the screen.
It's not readable.
Oh, okay. Then let me see. Is it better now?
Yes, sir.
Okay. Can we now move to the discussion questions? Can we move now?
Yes,
please.
Okay. So which forms of power are visibly seen in this scenario? You can unmute yourself and then speak out.
Can see the power of the chief who is supporting the project openly.
Okay.
power imbalance.
Yes. Which of them, Doc?
The chief has authority over his subjects.
All right. Any other person? Can we apply some of these in the scenario? So we have the chief has an authority. The people are afraid that they cannot go against the stance of the chief. Now, why do you think the chief will have open interest or support that they give the concession to the mining company? Hello? Hello? Yes.
Yes, Prof.
Now go ahead.
Yes, there's gender discriminatory at this point because women are not permitted to bring their grievances, meaning their rights are denied at this point. The chief is saying that the women and children, the youth has no right to contribute. So his power is in the form of autocratic decision he has made.
Okay. But that was a very good observation. I was asking a follow-up question that why do you think the chief would want to support that they give the concession to the mining company instead of his people farming on the land?
Okay. It's looking at the perspective of the town development and
Okay.
without considering the feelings of the people and how they will also feed on that land. So if he actually wanted the development of the area, it's good to negotiate with the subject on the mediation table so that they will all have win-win.
Very well. That is great. So you see that the Ubuntu philosophy are set in there. The chief is looking at the fact that the mining company might have assured the chief that I will build a palace for you. I will construct the roads in your area for you. I will bring development. I will bring all that. And the youth are going to get employment and all that. So the chief will look at the collective benefits of the community. And they say, okay, why not give them the chance to come and do it so that everybody benefit? Instead of allowing ACPSEA to go and maybe cultivate some okra or some maize farm or some cassava farm, which in the larger extent will not significantly affect the entire community. So the people will realize that the Ubuntu philosophy will work on them, and they have no option than to surrender or agree. Now, look at the theme of the national mining company. And then this slide, the partner issue we were talking about. They arrive with lawyers, financial experts, and a whole lot of team. They are even threatening that they will go to court or they will take legal action because if they don't agree and settle on the matter and sign the agreement, the time is not there for them and all that. So automatically you realize that the people that came, the mining company has stronger partner. Is that correct? Hello?
Yes, sir.
Is that correct? Look at the team.
Yes.
What warning signs of coercion exist? From the scenario, what are some of the signs or what are some of the signals as a mediator you could identify and see that there is power play in this process if you were there?
I can see that the company came with lawyers saying that if negotiation fail, they threatened that if negotiation fail, they are going to go for litigation. That's what I noticed because they've already come with their lawyers to the mediation table.
Great. Great. All right, so let's move to the third question. How can the mediator ensure meaningful participation? I think let's leave that question. We'll get to that slide, then we'll come back to that question. Should the mediator intervene if women are excluded from speaking? Okay, maybe when we go to the next slide, we can come back and answer the three questions. So, mediator strategies and techniques. So, as a mediator, you sometimes find yourself in the corner that you don't know whether you should take an action or not. You are trying to balance neutrality and fairness. I think since Monday, we are talking about the mediator's neutrality. You have to be neutral, you have to be fair, you have to make sure that the whole process is transparent and all that. But there are sometimes too, you see that if you don't intervene to support the weaker party, you may not be fair to that party too. So what is the neutrality concept here? Neutrality is supposed to protect. So impartiality and independence. You are not being partial or biased towards any of the parties. You make sure that the process in such a way that the party is independent. The party can talk based on maybe the person's own understanding and then feelings and not under any coercion and all that. There is equal respect for all parties. Trust in the mediator and the process. Neutrality. The parties should be able to trust you. There shouldn't be any incident where they will say that you are siding with one party and then neglecting the other party. Party autonomy and self-determination. So neutrality, that is what we are talking about. Now, fairness. To the right, you see awareness of power imbalances. As a mediator, what it requires is that you have to be fair. You have to be aware of power imbalances. You should know that on the mediation table, power play will happen. So you should be able to identify and then resolve them. Ensuring meaningful participation. You ensure that all the parties are participating in the process meaningfully. Protecting the voice of the weaker party. As a professional mediator, you are supposed to support the weaker party to also be heard during the process. Facilitating informed and voluntary agreement. You have to facilitate the process. Now, the question is not whether mediators should balance power, but how to promote party self-determination to the maximum extent possible. Now, what is the risk in this? So if you go to the neutrality side, the risk is that if we ignore the power imbalance, it can lead to unfair outcomes. And then over-intervention can also be seen as partiality. Now, if you ignore the intervention, you don't intervene, then it's likely that you can get an unfair outcome. And if you also over-intervene, then you also be seen as a partial person. So you see, the process is in such a way that the mediator would at all points try to be neutral and try to be fair. So we have a lot of work at hand to do. The mediator's ethical standard is to protect the integrity of the process so that power imbalance does not deprive any party of meaningful participation and autonomous decision making. The goal is to distinguish between coerced agreement and then autonomous agreement. As a mediator, you should be able to detect that, no, this agreement is forced. They are forced it on the other party. He's agreeing, but not from his heart. And that is where, if you are not careful, you arrive at a settlement, and the next moment, the parties will still be moving on to other channels of settlement. Is there any question on this before we move to the next slide? Hello? Hello? Is there any question? Yeah, any question on the mediator's dilemma? Hello? Or we should move on?
Yes, please.
All right.
Let's make
Okay. Now, practical techniques for managing power imbalance. Pre-mediation preparation. As a mediator, you have to ensure weaker parties receive legal, technical information before mediation begins to narrow the information gap. So we have the duty to help weaker parties, even ahead of coming to the mediation table. Caucusing, we talk about the private sessions. Meet privately with each party to surface concerns that would not be raised under pressure in the joint sessions. Reframe and summarize. So the video we watched this morning, the mediators made very good effort to summarize and reframe some of the statements the parties were raising. So actively restate and validate the weaker party's interests so they receive equal hearing in the room. Adjust pace and schedule. Avoid scheduling fatigue or rush timelines that disproportionately benefit well-resourced parties. So, for example, in our first session of the presentation, Mr. Isaac talked about the online mediation and all that, you have two parties that one has no internet connectivity. He or she cannot even buy bundle. Then the other person, or even is not having a smartphone or any gadget that can help the person to join the mediation, maybe online. But because the other party has all the resources and is even talking to you, the mediator, that if he is serious or he or she is serious, they can get maybe any internet cafe or get any gadget from a friend or any place to join the meeting. And even the time that the meeting is scheduled will not favor one of the parties, but because the other party is very powerful, he's able to manage his way through to schedule it. As a mediator, you schedule it at that time. You will not be helping the weaker party. So as a mediator, you have to be aware of all these dynamics and then try to help the weaker party. Co-mediation. Deploy two mediators. If you feel that only you are not able to do what you are supposed to do as a professional, there's nothing wrong getting a co-mediator, potentially including a representative with cultural authority or relevant to the parties. God willing, tomorrow we'll be talking about the cultural dynamics. Now, you have gone into a mediation room as a mediator, but you have little knowledge about the people's culture. Nothing prevents you from getting somebody who has a very good knowledge of the culture of the people to also facilitate the process as a co-mediator. Support for weaker party with party consent. So you let the parties know that they consent to it. Suggest legal advice, financial counseling, community support before signing agreement. But you seek their consent before you do all that. Partner coaching. So you have help weaker parties understand their alternative without compromising or become biased or partial. So you do that with the impartiality mentality. So ground rules, you set ground rules, establish explicit norms of mutual respect at the outset or the onset. You start, especially important across hierarchical culture. You set ground rules to guide the process. Then we have reality testing. Challenge unrealistic demands by either party, including those backed by institutional power. As a mediator, somebody is proposing a resolution that you yourself is not feasible. You have to challenge unrealistic demands by either of them. It could be any of the parties. You do that professionally. Let them vary the stance. Otherwise, the settlement will not be realistic. Then voluntary termination. Be prepared to end mediation if coercion is identified. An agreement reached under duress is not a mediation success. For example, doctor was asking about the chieftaincy issues. So you go into a mediation room with two royal family or the gate, then you end up by force trying to reach settlement when the two parties are not ready to reach settlement. When you do that, it is not a success, or that is not the aim of mediation. So you have to prepare that mediation process can be terminated. You may not reach any conclusion or any settlement. So ethical dimensions. When does power imbalance? So we have a ethical dimensions. When does power imbalance require intervention? At what point, as a mediator, will you consider or deem it necessary to intervene? Grounds for mediator intervention. So one is that coercion is evident. You see that clearly there is power imbalance here. One party is visibly intimidated, threatened, or cannot speak freely. Information asymmetry is extreme. One party can meaningfully evaluate proposed terms without independent advice. So one of them cannot do that. So you have even drafted the settlement terms, but the person cannot even read, or the person doesn't even know what is on the paper and needs assistance. But the person also has no resources or has no any available means to get somebody to support him or her. As a mediator, you are supposed to help the person to find an alternative or a way of also understanding the process before maybe signing or thumb printing. Consent is compromise. You realize that the consent process is compromise. The cultural, the emotional, and the institutional pressure is overriding genuine autonomy. As a mediator, you need to intervene. Vulnerable parties, children, domestic violence survivors, persons without legal capacity require heightened protection. As a mediator, this category of people, whenever you have an encounter with them, you have to protect them. Systemic injustice. Proposed agreement would perpetuate a clearly illegal or fundamentally unjust outcome. So there is a systemic injustice, and then the proposal or the settlement is likely to perpetuate a clearly illegal or fundamental or unjust outcome. You have to intervene. The mediator has limits. The mediators are not judges. You are not a judge. In our previous sessions, director keep hitting on it that you are not there to impose any judgment or any settlement on them. They should own the settlement so that the process can be meaningful and the settlement can be durable. So their role is to facilitate. As a mediator, you are supposed to facilitate, not to adjudicate what is fair. So when we watch the video, director advised that it is not your work to go and say that this party didn't do well, this party did well, and what you did was not right and all that. That is not your work as a mediator. Imposing balance may itself violate party self-determination. A weaker party may knowingly choose a compromise that observers consider unfair. So what you, the mediator, may consider that is unfair and you think it is the other party is weak, you may not be right because the person may choose to compromise. And as a mediator, you have to be careful and you have to know this. Mediator bias towards equalizing outcomes can itself become a form of power over the parties. So the mediator, you want to pose your nose in everything. So you are trying to get, in the name of fairness, you are trying to equalize the outcomes. It can be a problem in the mediation process. Cultural context matters. What appears as a power inequality in one cultural context may be different from another cultural context. So equality to an outsider may reflect legitimate customary authority. So you have to be aware as a mediator. The test is not equal outcomes, but meaningful process participation for all parties, which we have to take note. Reflection. Have you ever witnessed a mediator intervene to redress a power imbalance? And did it help or hinder the process? What would you do differently? So after this, we'll go back to answer the 3 questions we left at the top. Yes, let's reflect on this. Have we ever encountered something like that? It could not, it may be in the informal setting, in our family, in our communities, then you realize that the person that was trying to mediate the process intervened in a way. Did it help the process or it didn't help the process? Have you observed something of this kind before? Hello?
Hi.
Have you observed?
So,
I know, Reverend, maybe you, in the church you have observed something like that. Can you share with us?
pardon me.
I was saying that maybe in the course of duty as a minister, you might have encountered something like that. Can you share with us?
I've not heard you clearly.
I was requesting that maybe in the course of practice as a minister, reverend minister, you might have settled some dispute or you have encountered some dispute in your community, in the congregation and all that. That at a point the mediator
Yes.
or the mediator figure tried to intervene to resolve the issue. Did it help the process or it didn't help the process, given what you have learned this morning?
Yeah, it helps. In the sense that you let both parties understand or come to understand that since cultural aspect is part of us, when conflict arises, we do not try to ignore who we are and where we are coming from, but we look at how we'll be able to merge, we'll be able to eliminate that situation, then we move on for the sake of the future generations. And that has been wonderful.
All right, thank you. Josephine. Josephine, are you with us? All right, so let's move on. Now let's try to go back and then respond to the other three questions in the scenario we read earlier. How can the mediator ensure meaningful participation in that scenario? All right, so let's reflect on that. Okay. So the key takeaways or the takeaway here is that the mediator or the mediator's role is not to produce equal outcomes, but to protect the process integrity, ensure all parties can participate meaningfully, and that agreement reflect genuine autonomy. Practical techniques from pre-mediation empowerment and caucusing to co-mediation and voluntary termination provide concrete tools for addressing imbalance without sacrificing neutrality. The ultimate test of power sensitivity mediation is not the agreement signed, but the dignity preserved. So you have to reach a settlement, ensuring that the process was fair, and then people's or the party's dignity were preserved. So as we close the session, let's reflect on this and try to practice them. So we write a response to this statement. One power imbalance I will proactively identify in my next mediation is, so we write it in our notebooks. One technique from this session I will apply to address it is, then you write it down. One colleague or peer I will share this insight with within the next month. Then you do that. As you move on in your community, you can discuss with your colleague mediators and all that to also promote the work we do. I will end here, and then if there are questions, you can bring it, then we'll take it from there. Thank you. Are there any questions?
Okay. Yeah, I want to illustrate from the background I'm coming from.
Okay.
I've been dealing with this conflict over 15 years now. Since 2011, I've been working on it.
Okay.
And it has not been, it's a very difficult journey, dangerous journey, but in all, there have always been progress. Now, of late, I've established these platforms trying to involve some of these family members to reflect on our culture, where our forefathers have started, then where we are. We know Ghana gained independence 1957. It was being colonized by the British. Now, a lot of us are enlightened, and we do not have successional plans on our leadership roles like the chieftaincy, the queenship. And these are clans that, or tribe that has different clans up to 88. And there have not been any succession plan, which keeps on this conflict packing. As a mediator learning today, bring these people on platforms. How do we go about some of these issues? Because I actually want some to contribute the way forward, the solution, so that the future generation will benefit, not to still come back to that same situation. Because there's something I've learned on democracy, governance, law, and development. And when we are talking of governance, everybody has a portion to govern. So when it comes to traditional rules to govern, everybody has a jurisdiction to govern. So why this conflict of power imbalances? Why?
Okay. So I think I will comment, and then colleagues too also maybe add up. You know, on Monday when we started, we were introduced to the nominal value and then the fundamental values and all that. You will realize that there are some of the conflicts that are tied to some values that people cannot easily let go. So if you are, and that is exactly what the chieftaincy issues are all about. Sometimes, from where I'm coming from, to me, I don't normally see why people should be fighting for maybe a particular skin. But you see, the other thought too is that it is not about the resources or the financial gains, but it is about the name. It is about the generations to come. and they are tied to their identity. And it's difficult to let go your identity, because if you let your identity get missing, then it means you are also lost. You are not in existence. And so, as a mediator, when you go to the mediation room, you don't set timelines for concluding the mediation process. What I want to mean is that mediation can take several years. You said you have gone through it about 15 or more, 15 years or more. It can continue forever. So you don't set timelines, you only manage the process. As and when they are willing to go back to the mediation table, you go. If they are not willing, you cannot do anything about it. So sometimes peace or settlement, if you want peace more than the conflicting parties, then you not achieve any concrete results, because the parties are supposed to want peace more than you, so that you can be able to help them to reach settlement. But if it doesn't arrive, please don't give up. Keep the torch up and then continue with the process, hoping that one day you will reach a settlement. So, Reverend, it's part of the work. So don't be in a haste to conclude that mediation. You can continue until the parties are willing to surrender or to come to a compromise or a common agreement. Director, Mr. Isaac, if you are there, maybe you have some piece of advice for Reverend. I can feel that Reverend is going through a lot when it comes to this particular chieftaincy issue.
Okay, thank you. One thing we have to recognize is that as you are being taught to become mediators, um, mediation only ends when parties have agreed that the process has ended and that they have achieved the reason why they came to the table, or one of them say that they are not ready to go through the process again, or you, the mediator, see the need that going on with further mediation with the people will not worthwhile. So these are the only times that mediation become at a point where we say mediation has ended. But let us, as one of my professors said, he said, it is better to be on mediation for 10 years than to even to go to court and get judgment for 3 months. Why did he say so? He says so because in mediation, you'll be able to talk, you'll be able to discuss, and every day that you meet, emerging issues will come out, and individuals will be able to understand each better. Although they may not get a solution on that day, but they will be able to hear from the perspective of each of the parties. And through that, better understanding will be built. And through that, parties will be able to shape the outcomes gradually. So it may not take a day, it may not take a month, it may sometimes mediation can just take an hours, within 3 hours, within 1 hour, you can end the mediation. But some can take days, some can take months, some can take years. But then the most important part is that we don't rush mediation process that I want to solve this matter and give report. No, run the parties through the process. So don't run the parties, run the process. So that is the key word you have to know, that don't run the process, don't run the parties, run the process. So if you are running the process, so it means that at what stage are we? What did we agree to do today? What are the issues that we have to seek, maybe technical support to it? You do that. Gradually, you build the all the other issues surrounding the mediation, and to that, at the end of the day, you have better solution. When it comes to chieftaincy matters, one of the reasons why some of the chieftaincy matters are not been able to be resolved, or we have not been able to resolve them, is because every chief want to wield certain power, and sometimes the individual that refer the matters to are not doing what we are learning as mediation, but sometimes they will be doing what they think it is right or what they think they can do within their powers. So sometimes they do it within their powers, and at the end of the day, things will not work. So what sometimes I say is that it is better for some of the chiefs who are prominent chiefs that the parties respect to lead, but they should have professionals behind them who will now be advising them inside the room that now when you go today, do this, today, say this. And sometimes they can write something on paper for you so that you can be moving into that direction, so that at the end of the day, the glory will come to you, but we'll have a better solution that one we have been seeing, so that our chieftaincy system can be better. Because one thing is that if we are fighting over lineage, the court cannot tell us lineage. It is only the court is able to tell us lineage and who is the rightful owner based on document, that is evidence that we have presented to the court. But if we sit and we do the proper narration and tracing, so that is why sometimes, that is why yesterday I was telling you how parties can talk. Some of them can narrate, some of them tell me what has happened. So tell me the history behind this. Some people can narrate so that you can get to the bottom of it. How did this even stool came into existence? How did we establish this stool? Who was the first occupant? How did they get to these people? These are matters that even the court will not go and find out. You have to bring it to the court and show evidence to that. But through mediation, and if the parties are willing, they can sit, resolve this matter point by point, and they will be able to, and they can bring in people who understand the history better to narrate the issue for everyone to even understand. Sometimes if you are able to go through this mediation properly with the people, by the time you even finish them, they realize that even the person sitting on the throne may not be the rightful owner, but it may be because something happened, then there are people who were brought in. So you see that the rightful owners are even there, and these parties will make proper agreement as to what they want to do going forward, so that this matter can have a resting journey. So these are some of the things that we have to encourage individuals to do, that talking brings out issues. We keep talking, we keep communicating. It brings out all the underlying issue, and it helps us to understand the perspective of each other. And at the end of the day, we will be better to understand each other than fighting, doing acrimonies and other things, going to court and going to other places where a judgment will be made, and sometimes to go into our favor. Sometimes we get the judgment, but we ourselves, we are not happy with the judgment that we have gotten. So these are some of the things that mediation can do, and we can all prioritize mediation. And that is why when you come to the association, we are prioritizing mediation, that every member who comes on board should have a mediation background, so that it doesn't matter the area that you are practicing in conflict, peace, and security, but you have a mediation as the back of your mind. So when you encounter a challenge, or when you meet parties within your field, you'll be able to assist them with mediation skills. And that is what we sought to do. I hope my intervention has also helped in adding up to what Paul has already said. Thank you.
Thank you, Director, for the intervention.
Okay, so thank you so much, Papasi, for your presentation. We are grateful to you for making time for us. And we'll take a break here. We are going to break for, let's say, so between, let's have a break for 20 minutes, and we'll be back. So 20 minutes is now 12:40. So let's come back at, okay, let's say, well, yeah, let's give ourselves 30 minutes. So 1:10 we come back. So 1:10 we come back. 1:10 GMT. Other countries will be different. So please, let's take a break and we'll come back. So find something to drink, walk around small, and let's come back at 1:30. Thank you all. Don't log off. You can leave it on and you come back. Thank you.
You're welcome.
We're trying to bring you up to speed what we're going to discuss going forward, which is opening statements, and for you to understand it better. Right, so yesterday I asked you to prepare your checklist. How many of you were able to prepare it? Hello, how many of you were able to prepare it? Oh, yesterday we gave some assignment or you didn't do them. Hello, are we there? Are we back? I want to hear you. Tiny, Gloria, Josephine, Christine, are we back? Okay, Gloria is here. Oh, Kanye has dropped off. Okay, so let's see what we are able to do together. So get your pen and paper. Let's see what we are able to do together. I'm going to project a case study, then use the case study to prepare an opening statement. So assuming you have these parties before you. So you have these parties before you. You have James owns a commercial property which she leases to Mike, who operates a popular cafe. James claims Mike has violated several terms of the lease, including the late payment of rent and unauthorized renovation. Issue: Mark argues that the renovation were necessary to attract customers and that he informed Jane verbally. Then Jane insists on adherence to the lease terms and seek compensation for unauthorized changes and late payments. Mike believes these lease terms are too stringent and outdated. So require the mediator's task is to address the lease violation, discussion potential amendment to the lease terms, and find a fair resolution regarding the renovation and late payments. Let's so assuming you are the one to do a mediation and you are meeting these two people for the first time, what are you going to tell them? How are you going to welcome them? How are you going to so going back to what yesterday we discussed with you, so as was being also shared in the video. So you were told that when the parties come, definitely you have to what, welcome them. You have to when you welcome them, you do introduction, then you do what? So the next, as I mentioned, that go and prepare your checklist. So let's go. So use this case study and let's go. So let me mention names. Um, okay, Josephine, let me hear you. How are you going to do an opening statement with these parties? Hello, Josephine, are you there? Okay, if Josephine cannot hear me, let me go to Gloria. Gloria has
Uh,
gone. Okay, Josephine, go ahead.
of course, if we are starting off, assuming I have introduced myself.
Yes, so start introduce yourself and welcome the party. So using this case study.
Uh, assuming it's the morning. Good morning, everybody. Thank you for making it to this mediation table, and I'm happy to meet the parties involved, Mr. So and so, and maybe Mr. So and so. Thank you very, very much. We are looking at your case. We have listened to it before. Now we are having our second listening, and we know the case is around commercial property, and we are going to look at several issues regarding the case. Mike, is it true that your
No,
argument was based?
you are going outside. We are saying that just an opening statement. What is even an opening statement? That is where what you should ask yourself. What is even an opening statement? Opening statement is the statement by the mediator welcoming the parties to the mediation, introducing the mediator, introducing himself, allowing the parties to introduce themselves, the mediator telling them about the process, telling them about what will happen in the process and their role, the mediator's role, before you move into the transition to the other stages where the parties will be given the opportunity to talk. So what we're saying, do an opening statement with this. What we mean is that use this case study. So, for instance, if you are using this case study, you know that Jane and what Mark, you may not know their name and that they have come, or you might have seen their name on the file. But one thing is important that at least let them um, mention their name
No.
or introduce themselves and how they want to be called. So, for instance, welcome. I want to welcome the two of you to the mediation. My name is Isaac, and thank you for appointing me to serve as your mediator. How may I call the two of you? How may I call you? So, Mark may mention his name, and Mark. Jane will also mention Jane. For the purpose of then you, the mediator, can say for the purpose of the mediation, you can call me Isaac. Are you also comfortable with your first names? They will tell you yes or no as we watch in the video in the morning. So I want you to bring this perspective into bear because you are going to practice. So we want to see how you're going to practice, how you're going to help individuals that come to you. Because when they come to you, you must introduce yourself. They introduce themselves. You introduce. So after introducing yourself, finding out whether they want to be called by their first name and they are okay with that, you thank them. So thank you. Then you move on. So before we get going, I would like to check with you. You can check timing. So we agreed, or both we agreed earlier during my conversations with you that you can do up to 4 hours. I want to check it with you if anything has changed or that the 4 hours is still in. They will give you feedback. And also, I want to find out whether the two of you has authority to resolve this matter today. Are there any one that you have to seek authority from? If they can say yes or no. So, particularly if it is a commercial matter, you find out from the people representing the company whether they have authority to settle and what range of authority is it absolute or at a certain point they have to go and take permission. Then you thank them and move on to a stage where you also you introduce them. So by way of I although I share that you might have known or understand mediation, but let me take this opportunity to briefly share with you what mediation is. So mediation is a process whereby a third party, like me as a mediator, assists you through communication, because sometimes, because we have maybe because of the issues surrounding the matter that we have brought here today, communication becomes ineffective. So we are not able to hear the other side very well. So my role is to help you to understand each other and to drive home the discussion that will be beneficial for the two of you. So my role is just a facilitative role to help you, and your role is to talk and make the necessary all the decisions that you need to make today. Any agreement that will be made from here will be a decision that has been agreed by you. So in mediation, let me also say that because we are meeting and talking, I want to assure you that everyone will be given the needed opportunity, equal opportunity to share their views and share their thoughts. And I want to encourage you to be gentle, be honest, be open, be specific, and be sincere, and also be able to talk. If you do not understand anything, please do ask. Ask us. We will be able to explain further to you. Again, let me also share with you that one particular importance of our mediation is that everything that we discuss here is confidential, and I cannot divulge any information that you share with me to anyone. You cannot also share the information with another person who is not on the table. The only thing you can share is the outcome. At the end of the day, what were you able to achieve? That one you can, for the purpose of implementation, and those you can share with other people. So a mediation is confidential, and for that matter, let me refer you to our law, which then you can quote the law, section 79 of the ADR talked about confidentiality. With your permission, let me read it to you, read it to them. Let me also share with you the disclosure of information, which is on section 78. Then you read it to them. So then you tell them. So again, let me also say that at a point where we face difficulties or we face impasses and communication becomes difficult, I may see each of you individually, which is called caucusing in mediation or private joint meeting. And whatever we discuss there is also confidential between with the person that I will meet there. I will not share with anyone what we discuss there. So at a point, if the need be, I will do that. You can also request if at a point you want to meet me alone. That is also allowed. So want you to understand that as well. So let me also emphasize that mediation is voluntary, and no one is being coerced to sit on this table. You are being encouraged to participate in this process, but you are not being coerced. It's voluntary process, and every decision that you take here will be an agreement between the two of you. And also, but having agreed to sit on the table, we want to encourage that you don't just get up and walk away. But if there is something that you do not understand, you ask for clarification, then we'll be able to clarify for you. Is that okay for you? Is there any other thing that you want us to share with you? And then you go on and talk about other auxiliary matter. There is a washroom here if you want to go to the washroom. If there is water here, if someone wants a coffee, there's a coffee a machine there. These are some of the things, auxiliary matters that you add. And also, let me also indicate that all these things that I've said have been put into a format that we call consent to mediate is on the form. So please, you can go through and sign. And going to that, let me also say that every discussion that we do here, until it has been reduced into writing and signed by all of you, there wouldn't be any outcome. So once there is an outcome and you sign, it means that it is binding on you. So I want to encourage you all to go through the process with that open-minded, be free, share your perspective, and be able to talk so that we can understand you better. The other party can also understand each other, and that you can have an agreement that works for all of you. So let's also not think about only today. Let's think about the future, the tomorrow ahead of us, and what we can do together as we move on. So be rest assured that I am impartial. I do not side with any one of you. I don't have any interest in this matter, and I do not want anyone to also persuade me to toe their line, because I am not the one to make any decision for you today. Every decision will be made by you, and the trust in the process, and let's have a good process. Right. So this will be your introduction. That is the introduction or the preparation stage. That is what we call the mediator's opening statement. So every mediator, you have to understand how you can give an opening statement to parties on issues and be able to, for the parties to feel at ease, understand why they are there and what they are there for, and what is about to happen in the process, the structures that they are going to go through. So you can talk about we are going to go through various stages of the process. So what I'm doing with you is what we call my opening statement, which is the part of the preparation stage. At the end of the day, I'll give the platform to you for you to also make your statement. Then after that, we'll create an agenda from your statement and use it for discussion, and we move on till we get a solution. All these things are what the mediator can do for the parties. So it is important for us to recognize that and be able to function through that. So through that, we can assist the party. So that is why I gave this. So yesterday I asked you to go and prepare something, and so that when you come, so once you are given this, you should be able to do them. You should be able to practice them. You should be able to facilitate a mediation with the parties when you are giving a case study like this. So what you are going to do is that I'm going to select one of you to be a mediator, then someone will also be Jane, someone will also be Mark. So look at the case study well. So we are starting the role play from now. So Kanye will be the Mark, then Josephine will be Jane, then Reverend Dr. Gillian will be the mediator, so that we see how we take them through the process. So mediator, you have the floor.
Hello, Madam Gloria. Madam
Hello.
Christine, you are welcome into my mediation consult. I'm pleased to meet you. I'm Reverend Dr. Gillian. You can please call me Doot by my surname. And you can comfort yourself. Welcome
Just call
once
me Jane.
again. Yeah, Madam Christie, you meet Madam Gloria. Madam Gloria, you meet Mr. Keye Abusia Feli, then Mr. Josephine.
So your
Please, you
parties are
pardon me.
sorry, your parties are Jane and Mark. Josephine is serving as Jane and Kanye is serving as Mark.
Okay. Hey, I've not familiarized the name very well. My parties are Gloria and who? Christine. Oh, hello?
I said your parties are Kanye and Josephine. Josephine is playing the role of Jane. So your parties are Jane and Mark. Josephine is playing the role of Jane and Kanye is playing the role of Mark. Kanye, can you hear me?
Yes.
Yes, I can hear you.
So those are their roles. Kanye will play the role of Mark and Josephine will play the role of Jane. So you can go ahead.
Okay, let's start all over again. I'm Reverend Dr. Gillian Savlia. Pleased to meet you, Madam Gloria, Madam Christine, to this
Hello, we are
afternoon.
not. Hello.
Hello.
Please use the case study on the screen. So you are meeting Jane and Mark. So you are not meeting Christine and Gloria. You are meeting Jane and Mark on the screen. So this is the case study you are using. Jane owns a commercial property which she leases to the Mark, who operate a popular cafe. Jane claims Mark has violated several terms of leases agreement, including the rent payment and unauthorized renovation. Mark argues that the renovation were necessary to attract customers and that he informed Jane verbally. Jane insists on adherence to the lease terms and seek compensation for the unauthorized changes and late payment. Mark believes the lease terms are too stringent and outdated. So your parties are Jane and Mark, and Jane and Mark know
Jane.
themselves. So you welcome Jane and Mark and move on. Gloria and this is not Gloria and Christy. Okay.
Okay. Okay. I was rather looking on the screen the names that are there. Okay, then I'm sorry. Okay. Good afternoon and welcome to today's mediation. I'm Grillian Sabalia Dut. You can call me Dut for short, but it's your name. So, Madam Jane and Mark, you are welcome. Feel
Thank
free, comfort yourself. We are going to have a short interaction or mediation. There's a washroom around. When you take your immediate left, there's a corner you can free yourself when you want to free yourself. Or if you want water, you can please draw my attention. If you have to take a medicine or maybe you are hungry alongside, you can please draw my attention so that you can excuse yourself. Please, on mediation process, you are allowed to speak from your mind without any interjection. Feel free to speak whatever bothers you. You are welcome once again. Thank you. So, party, you please introduce yourself to each other.
I am Jane, the owner of the commercial building where that has been leased to Mr. Mike.
Okay. Ahmad.
Hello, everyone. I'm Mike. I'm operator of Popular Cafe, and I
Okay.
rent the property from Mrs. Jane. Yeah.
Okay. Then thanks for doing so. Can you be pleased by someone call each other by the first name? Will you be okay?
Yes.
Yes, you can call me Mike.
Okay. Okay, you are welcome once again to this mediation table or panel. Actually, can you please tell what happened or how the company has started, Miss Jane?
I am the landlord to Mike. I have leased this building to him for the last 3 years. But now I have discovered that he has made changes to the building, things that were not in the lease I gave him. He has undone the floor of the house, changed the tiles that I had put there. He has also changed the type of the windows. and even change the color of the walls, and also change the positioning of the lighting system, which I do not like because it was not in the list. And to make things worse, he is in rent arrears. He has not paid rent for the last 3 months. And every time I talk to him, he becomes angry, and he even wants to beat me up. So I'm now going to take him to court.
Thank you, Miss Jane. Mr. Mark, you are on the floor.
Thank you, Mrs. Mediator. First, I would like to say that I value the opportunity to discuss these issues openly because I really want to maintain good relationship with Jane, and of course operating my cafe. For me, the renovation I carried out were not intended to violate the lease agreement. And the cafe business is, um, we have customers, and the customers have expectation that the cafe have to provide, and that's made some significant some changes over time, and it's just to improve the space and to be more attractive and functional. Otherwise, the business will not be sustainable. Will not be profitable for us. I understand, Jane, that we need formal authorization for renovation, but as I said, we communicate verbally about those improvements, those changes, before we proceed.
This gentleman never sought consent. He never told me, and he's joking with my property. I'm not going to allow this. And help me to move him out completely, even before the end of the lease.
If Jane allow me to finish, and I think at that time I believe there was an understanding between us, even it was verbally, and at least no objection was raised. So that encouraged us to go ahead with the renovation. And regarding the rent payment, I know there was delay and in some occasion, but it's not intentionally and not in bad faith. So when we are running such business, we have sometimes financial constraints and challenges. So, and I remain
But you see,
committed.
you've been running the business for months. You make money. I see clients in the cafe.
Miss
Why are
Jane?
you unable to pay my rent?
Hello, Miss Jane.
Yes.
With due respect regarding to mediation, the rules were spelled out to you when we were about to start, that each and everyone is given the opportunity to express his or her opinion. Can we please go by that?
Madam, me, I want my money.
Yeah. But could you please allow Mr. Jane to finish, Mark to finish?
Okay, okay. But I'm very annoyed. Very, very annoyed.
Please, when issues like this come, we try to look the way forward in solving them. Yeah, as humans, it's bound to happen. But let's see how we'll be able to resolve it. Can we please hear Mr. Mark?
Okay, thank you, Madam. Coming here today, my objective is not to avoid responsibility, but just to find a solution. And I'm willing to discuss a way to address the rent issue, the delay that I have, and the possible arrangement that we can agree on, and also about the renovation. And on top of that, because Jane is talking about the lease agreement, if we can have some, we can have some, some amendment on those terms, that will be benefit for both parties. And I hope we can reach an agreement. And as a tenant operating a business and investing in the business and in the property, I think we can agree on new terms that will be good for both of us. Thank you.
Thank you so much, Mr. Mark. Yeah. Can you have a cup of water to refresh yourself once again? I've set water on the table. Is that all
Thank you.
right?
Me, I'm okay.
You're welcome once again. Thank you for both bringing your grievances to the mediation table. Okay. Madam Jane,
Yes.
as you said, Mr. Mark, what would you
Have
say? You've heard Mr. Mark
Me,
speaking.
I think he does not want to. Okay. I think he does not want to pay my rent because he thinks he has he has made changes to the building, and in case he leaves the building, they will still benefit me. But me, that is not my intention. I, I intend to have my building stay the way it was initially. So what I'm asking him to do is to ensure that he pays my money. So as we sit here, I want to know when he will pay my money. I am open to an arrangement, but it should not go beyond 3 months. I want all my money in because I have things that I need to take care of for my family. Yes, I'm really, really disturbed.
Hello?
Yes.
Yes. Thank you for opening up to show some of the challenges you are encountering. But have you asked or have you told Mr. Mark some of these issues that you are encountering?
I don't have to tell him what my problems are. He has an obligation to fulfill, and he's supposed to honor that obligation. How would I go discussing my personal things with a tenant? That's no. He just has to honor his obligation.
Hello?
Hello?
Okay. That's okay. Would I know or will I know if you could confide in me? Can we have some caucus?
There's no need because the case is very open. I need the
Would
man
want
to
to
pay my
discuss
rent.
me?
Even the renovations, but let me have my money. The key issue here is my money. I want my money.
Okay. Yeah, Madam J.
Yes.
Oh, the network. Hello, Madam Jane.
Mm-hmm. Yes,
Yeah.
ma'am.
Would you mind for us to have a private meeting or a caucus where you'll be able to
Me?
express some of the things to me without Mr. Mark? And it will
I
be
am not,
confidential. It will be
madam.
confidential,
If you want to,
except
if there's anybody you need to talk to in private, it's Mr. Mike. You go sit with him. Let him give you the plan on how he's going to pay the arrears of the rent, and give me a report. Me, I'm not listening to any other thing, madam. No way. With all due respect, you talk to Mark. Let him come up with a plan and come and tell me. That's all I want.
okay. That's okay. Thank you so much. Mr. Mark, are you there? Mr. Mark,
I'm listening to you.
I think you've heard Madam Jane. Would you mind if
Yes.
there's something that move privately, then you feel free to tell me, because she's referring it to you that you could come out with a plan that will be favorable to her. Would you mind?
I don't mind so far as we can reach an agreement. I can draft a proposal for you for how I see the things and how I'll be able to pay the rent to her. But again,
Okay.
as I said, the time we did the rental agreement, things happen and things have changed a lot in the environment. So there's a need to have some new agreement, amendment to our lease agreement, so that we can face what we are having now. And of course, the renovation there is investment that we did. So I think that should be taken into account. And so per se, I will do my proposal, and if you don't mind, and if she agree with it, but I just insist that we need to reach an agreement, and we need to change the terms of our lease agreement to adapt it to new environment. Thank you.
Okay. So, Mr. Mark, what are you putting on the table? What is your proposal like? Hello?
Hello, ma'am. Yes,
So, what are
I
you
think
proposing? At what percentage? What amount?
I don't think it's about the amount. The amount is already fixed for the rent, and it's just the late payments that we agree to pay, but not uh, at the same rate, because it's um, how do you say, uh, old payment that we have to do now. I will not be able to
Okay.
pay all at a time, but we can put uh, schedule, um, and for the monthly payment that we are doing now, we can just increase to take into account the late payment to be able to resolve it by the end of the year. So that's my proposal. But again, I think we have to uh, amend our agreement so that anytime we have renovation, it should be taken into account, and the owner should also be part of it. That will reduce our rent in time, if possible. But because at the end of the day, the property will go back to her. So we will not take it away or renovation or break down all we did at cost. That's my point of view.
Okay. Mr. Mark, please, you made mention of paying at the end of every year. Which month precisely?
It's not every year. I mean, the payment, the
The
rent is
end
continuing. It's
continue.
monthly rent. Yeah. So instead
Okay.
of paying like 200, which is the rent, we can pay 300 or 400 to take into account the late payment, and so that by the end of the year, we pay all the late payment, adding to the current payment. That's, that's my proposal.
Okay. Then thank you so much for having the confidence in me. Would you mind this information uh, is given to Miss Jane?
Not at all. I don't mind it because that's why I said it. You have to tell her
Okay.
about the what we propose, and also the need to have amendment to our lease agreement, because we cannot continue. We are business person. We are operating business, and it's not easy uh, for us. Though the business uh, is successful, I mean, we are taking into account the cost of living, the cost of items and things like that. And we want to stay in that property. We do renovation, and we want Mrs. Jane uh, to bear with us and to take into account those renovations, and at least to understand that there was a need to do those renovations. And she knows that we rent the property to operate business, so you should understand those.
Okay. Thank you so much. I'm assuring you that all what you've said will be brought on the table, and have the confidence that there will be a win-win. Okay. Hello, Madam Jane.
Yes, madam.
Yeah, I'm back to your side, and we are going back to the mediation table. And I welcome you back once again on the mediation table with a proposal from Mr. Mark. The proposal is that he would be in agreement to amend your terms of how you want the company to run. So what do you say?
You know what, madam? Mr. Mike renovated the building or the room where he is running the cafe for the benefit of his business, not my business, which is leasing a building. So I will still insist. I do not agree with the renovations he has done in the first place, but I can ignore that for the moment. But I need my money. So let him send in the money. Let him send in the money. Up to the year, it is a bit too far, but all I want is the money.
Okay.
I can ignore the renovations, but my money must be in full. And there is no way he can tell me to change the lease, because every tenant is having the same lease.
Yeah.
And this is family property. Yeah. So we're not going into headaches of changing the lease. Let Mike honor his word that by the end of the year, he will have paid. And if he is not, he should be ready to be evicted. And we shall retain, I will call in auctioneers to help me recover the rent arrears. That one is clear that way. I don't have time. Me, I have to go. I have other business meetings to attend, madam. So me, I'm packing off and going. I'm not going to deal with such men who want to even con women who are in business. We are trying our level, but very terrible. I don't want to deal with this con man.
Madam Jane, thank you so much. There's a proposal Mr. Mark is putting on the table. The proposal is that he has challenges, but he would want to continue to rent the place. He still wants to do business with you. What could you do to keep him solving some of his issues that he's encountering in life or in this business?
Well, the thing is this: we have 6 months to the end of the year. If he clears the arrears plus the rent for the upcoming months, I will give him one waiver month, the last month in December. But if not, if by November nothing is going, tell him he has to move out. And I will auction all his stuff. My auctioneers are on standby. For now, madam, I have no time. Me, I have left. You ensure my money is here.
There's another proposal Mr. Mark has put on the table, and since it will be paid at the end of the year, he will be paid into another months, like from $200 to $300, so that it will have some balance into another month, in order to also cushion him in business. What do you say?
For as long as he is paying something, I have no issue. But ensure the arrears do not go beyond what is already there. For these other months that is still operating in my business, I will demand my rent. So he'll be paying the rent plus the arrears. This is business, madam. You cannot joke. You cannot joke with people. We have sweated to put up such buildings, and we have such foolish tenants coming in. I'm tired of Mr. Mike. I'm tired of him.
Hello, Madam Jane.
Madam, I
Yeah.
have gone. You ensure he pays my money. I am gone, and I'm not listening to you anymore.
Could you please mind if I call Mr. Mark for you to hear his side of story and how the proposal has been?
I have heard you. You have reported his side of the story, madam. I think I've allowed some leeway to have him pay the arrears, including the pending rent for the next few months. Let me have everything in by November. If he honors this, I offer him a month for free. He will not even pay a single cent. So in that way, I think I have finalized this case. And I will keep quiet until November, until I see him pay me. If he doesn't, I will auction all his hotel merchandise.
Hello, Madam J.
Mm-hmm.
Madam J. Yeah.
Yes.
Let's just see if we can meet on the mediation table, because he has also made some proposal which you are willing to inculcate them. Now, maybe there are some other views or other things you've not known about Mr. Mark. Maybe it could be of help. Can you please hear him? Mr. Mark? Hello, Mr. Mark?
Madam, me, I have gone. If he had issues, he would have come and spoken to me. He didn't have to get us to this mediation table. I am not the problem. He is the problem. So let him just pay up my money. Let us meet in November when he has paid everything.
Madam Jane. Hello, Madam Jane.
Hey, Madam Mediator.
Yeah.
Let him. You just
Please,
have him honor his
exercise
word. Period. That's all I want.
patience. And let me invite him to the mediation table so that we can have the proposal. Would you mind if we could reschedule it? Should we reschedule it? It's like you are a bit stressed, or would you walk around? Will you refresh yourself so that we come back to the mediation table, please?
No, I have told you I have other engagements to attend to. You reschedule this mediation.
Wow.
Hmm?
Okay. But as humans, as businesses, as we meet each other day to day, I know he's willing to do part payment of the arrears like you are demanding. So would you hear him how he wants to also fulfill this?
Hmm?
Hello, Madam Jane.
Yes.
Hello. Can I talk?
Yes, please.
What do you want to say now?
There's a proposal on the table.
Madam Jane,
The
I think
yeah.
yes, I think if we agree both to come to have a mediator is is that we want a solution and we want to at the end of the day have an agreement as to how we go ahead. But for what you are saying and for the acquisition that you made at the beginning and things like that, I think it's like you are not in position to accept any solution that will be good. And For me, I have no problem. I have no problem. I have my business, and I think I want to continue with that business. I know, and I said it before that I recognize my responsibilities in this matter. So for me, my proposal is toward having solution to have your money paid, and that is not an issue. And I think it's just the how I'll have to pay and how long I will pay. And so, and I propose to pay until the end of the year the arrears. But I think you said you want your money back by November. That's not a big deal. I think we can do that. But beside that, I said also that we have to review the term of this agreement because there are many changes now in our environment, and that's my main concern, that we should agree, we should have amendment to the lease agreement. And if you can have that, that will comfortable me to continue the business with in your property. That's my point. As for money, I think it's okay. We understand each other. If you agree, I will pay. I will pay the arrears uh, and the current rent also. Thank you.
I think
Hello, madam.
first, yes, maybe we can review the things later, but first things first, let
Yeah, the
him
floor.
clear his arrears. I cannot amend before he pays the money. So we shall, once he has paid, we shall start afresh. Then see what needs to be done, what needs to be improved. But for now, let him just pay the arrears as we have agreed before November. Then, if he behaves, that's when I can consider a review of the lease. Otherwise, for now, madam, I I don't want many stories, and I think I'm done. We schedule it until he acts on his word.
Mark. Hello, Mr. Mark. Hello, Mr.
Okay.
Yes,
Mark.
yes.
Thank you all. Let me pause you here. So thank you,
Okay.
the mediator and the both negotiation teams. So thank you. I think the mediator, you've done well. Any comment from the others who were observing, Christy and Gloria, please, Christy, Gloria, and also the parties. Any comment from what the mediator did? Hello, Christy, Gloria, comment. And the parties too, you can comment.
Hello.
Yes.
Yes, so please, with the mediator, since we were talking about opening statement before we started the case study, I think we omitted a couple of things from our checklist. I don't know if I got, my line was breaking at some point. I don't know if I got everything. But with the opening statement, after welcoming them, the confidentiality, I didn't hear about that side, explaining the whole mediation process, as they can work out anytime they want. Nobody is coercing them to sign any agreement. He or she is not deciding for them. I didn't get those aspects. I don't know if you mentioned, but I just didn't hear it as well. So that's the little observation I had.
Okay, thank you. Gloria, are you able to talk? Okay. Okay. All right. So let me introduce Madam Anas, who is also here to help with the role play. So and also talk about opening statement. So Madam Anas, welcome, and please the floor is yours.
Mr. Asari, thank you. Good afternoon, everyone.
Good
Grateful to be
afternoon.
here.
No, madam.
Yes, I'm grateful to be here. So I just came in. I'm not too sure where you got to, but we are talking about opening statements. When parties come before you as mediators, your duty is to, most often they are agitated, they are angry, they are bitter, they have all these mixture of moods. Your duty as a mediator is to show some confidence in what you are doing for them to have that confidence that they've come to the right place. And so your demeanor, your approach, your skill, parties will be looking at you, assessing you to see if where they have come to, they have this confidence that their problem will be resolved. And so from the time you engage them, you need as a mediator to portray that kind of confidence, that kind of how do I put it? Yes, that kind of warm reception, that kind of, so that the parties will have that confidence in you. It's important that you do not fumble as a mediator. It is important that you have your checklist like we are doing now, and then you go through the checklist. Don't be in a rush to hear the parties. It's important you prepare them very well. If they are well prepared, you will not have much problem. If you don't do the preparation, your opening statement well, then there'll be a lot of interruptions, there'll be a lot of hurtful words here and there, and you always will have to separate them and all that. And so I'm happy we have gone through the opening statement, and as you practice continuously, realize that sometimes you may not even need to be referring to your checklist. The parties will think that you don't know what you are doing. So at a point, you have to memorize your checklist have a plan in mind as to what you do first, what is the next thing, because mediation is structured and it's based on principle. And so I normally will want to do everything before I come into giving rules and giving regulations so that you don't deter people. Most people don't want to sign documents. And so it will depend on you, even though mediation is voluntary and you have to let parties be aware that it's voluntary. You will need to um, help them to come to that realization that, they need to resolve their problem. As for conflict, they will come. What is important is to resolve it so that life will go on. If it's business, you continue in business. If it is a family relation, we continue in the family relation. If whichever relationship you have with the party, that should continue. And so we encourage them to always use ADR and, for that matter, mediation to resolve their problems. Thank you very much. I think that will be my opening statement. I don't know how far you have gone in the checklist. And so as we go along, issues will come up and then I'll have more to say. But one thing that parties will always look for is your neutrality. Your neutrality. It's very important that they don't see you kind of tilting towards one party. So anything you do to one party, should be done to the other, so that a party will not be left out, a party will not complain. And as a mediator, confidentiality is also very important. And so you need to assure them of that confidentiality. And even the parties themselves, they shouldn't go about discussing issues and this said this person said that. No, even the party themselves, they need to practice that confidentiality. What goes out is the fact that the matter has been resolved and going forward, relationships have been restored. Okay. And one other thing I want to talk about is authority. You need to always check, be sure that parties before you have the power uh, to take decisions, because if they cannot take decisions on their own, they need to consult someone else, maybe their lawyer, maybe a grown-up, maybe a company head or whoever, to help them in the decision. Then you will be wasting time mediating. Okay, so Mr. Asari, that will be my opening statement. But if there are questions, then probably it will help me, guide me to what to say next. Thank you.
Okay, so maybe you can use case 32 and go on with the class with them.
All right. Okay, case 32. Right. So how many people do I have on board?
I think
7. Is it 7 or 6?
and it's I think actually five. You have Gloria, Josephine, um, Candy, and Reverend Dr. Gillian. So those are the people you have.
There's one
See,
name just joining.
that is a facilitator. She,
Okay. All
uh,
right. All right. So um I wouldn't mind you calling me a nurse. And so if you are also okay with me calling you or using your first names, that will be fine. So I have Gloria, Josephine, Kanye, Reverend, and then Christine. All right. Thank you very much. So then we'll go to this case study 2. And I would like one of you to read the case study for us, if you don't mind. Any volunteer to read the background, the story?
I read, Madam.
Please go ahead.
After the death of their parents, siblings Sarah, Tom, and Lisa are in conflict over the division of the family estate, which includes a house, some valuable at prices at pieces, and a sum of money. Issues. Sarah wants to keep the family house, which Tom and Lisa are willing to sell. 2. Disagreement over the valuation of the art pieces and the distribution of the process. 3. Emotional tensions and unresolved issues from the childhood resurface, complicating the mediation. Require facilitate a settlement process for the parties. 1. To reach an agreement on how to fairly divide the estate, addressing both the financial aspect and the emotional concerns.
Right. Thank you very much. So to the whole class, who are the parties? Who are the parties involved? Who are the parties involved? Yes. Who read? Was it Gloria? Okay, so who are the parties involved? Yes, anyone? Josephine, your mic is
The three
okay.
siblings.
Josephine, go ahead.
The three siblings.
Come
The three
again.
siblings.
The
The
three
three
siblings.
siblings.
All right,
Yes.
the three of them. The three of them. Do we have a claimant? And do we have a respondent? From this case, do we have a claimant? Do we have a respondent?
They're all claimants.
They are all claimants.
Yes. We have
There's no
claimant and
respondent.
we have respondents. Sarah is the claimant, Tom and Lisa are the respondents.
Okay, that is fine. Do we all agree that
Yes.
Sarah will be a claimant, and then the other two siblings will be a respondent? Okay, that is fine. So someone just mediated the case. We'll exempt that person. Can we have another mediator, a volunteer, who has never mediated before? It's very important you practice. If you don't practice, you think that, oh, this is simple. When you're in the seat, it's a different story. So can we have a mediator, please, who has never mediated before? Yes. Just have you mediated before?
No.
No. Can you try?
Okay.
You don't mind, do
Okay.
you?
Okay, it's okay. I will try.
Right. Nice one. Nice one. So we need Sarah. Who will play Sarah? Who will play Sarah? Who will play Tom? And who will play Lisa? We have our mediator who is playing Sarah. Can you volunteer so that we go quickly? Or I should mention names. We are not many, so you will take part. So the earlier the better. Okay. Kanye.
Yes, ma'am.
Help me. Yes, you're a male, so you be Tom.
Okay.
Yes, you are Tom. Reverend. Can I
Yes,
hear your
madam.
voice? Okay, female,
Yes.
you be Sarah.
Okay,
You
madam.
be Sarah. And then Lisa.
Okay.
So Josephine is our mediator. Reverend is Sarah. Kanye is Tom. Lisa. Gloria, will you be Lisa?
Let
So, I mean, I'm at the
Let
hospital at the
Christine be the
moment.
Lisa. I think Gloria is at the hospital, so
Oh,
she's listening.
sorry. So Christy, you will be Lisa, right? Okay,
Okay.
right.
Okay. Okay.
So you take look at the story again.
Mm-hmm.
Look at the story again. Look at the issues. You are fortunate the issues have been spelled out for us. So Sarah,
Mm.
look at your issue. And then Tom and Lisa, look at your issues. This is a mediation. So we are assuming that the claimant is Sarah, who has come to the center. What is the name of your center, please?
My
Just
center is the Peace Restoration Center.
case.
Peace.
Peace. Oh, okay. I heard
Yes.
case. Okay. So I was
Peace.
wondering what will be happening there. Peace.
Okay.
Okay. Peace is fine. Peace Resolution Center. Right.
Yeah.
So
Okay.
yeah, Sarah has come to complain. So she's a
Mm.
claimant, and the issue is among the siblings. And so
Mm.
you've written to Tom and Lisa. They have graciously obliged. They have come to your center. You have discussed with them and you set a date. Today is the date for mediation. You have your checklist by you. I want you to use it. And so kickstart the mediation process. We are all listening. The rest of us, we are taking notes. And then we are also checking it by our checklist to be sure that mediator is on course. When we are done, we'll hear your comments. Okay.
Okay.
Madam Mediator,
Okay.
let's carry on. So we have the next, say, 20 minutes. We
Okay.
have the next 20 minutes. So kindly go ahead.
Okay. Uh, good morning to you all. My name is Josephine Mirembe, the proprietor of the Peaceful Resolution Center. I welcome you to this center, and I believe at the end of this session that you agreed to all participate in will come to a mutual agreement, and we shall be happy with each other. I am glad you honored my invitation to this mediation session. Before we move on, I would like us to agree on which of your names we shall be using. Is it okay for me to be using your first names? That is Sarah, Tom, and Lisa. Are you okay with those names?
Yes, madam. Yeah, okay.
Yes, please.
And Tom, I haven't heard your voice. Mr. Tom, would you be having an alternative name that would like us to use? Tom, is Tom there? Are you with us? Okay. It's a little tricky here, but Mr. Tom, kindly allow me to refer you to Tom. But should you feel that in the course of this session, I need to use a different name, please feel free to let me know. But for now, since I knew you as Tom, allow me to use the name Tom. And for Sarah and Lisa, I think there are no questions about the names you wish to use. Now, feel free to open up, and I would like you to know that every opinion, every concern you raise is valid. And I request that we all respect each other's opinions, avoid any confrontations, but ensure that we respectfully respond to the concerns that will be raised during this meeting. I want to trust we all have enough time to be part of this deal, and we all should be able to end well. So I now wish to call upon Sarah, because it is Sarah who approached me about this matter. I would like you to openly share your sentiments with your siblings, Tom and Lisa. Please do so, Sarah.
Thank you, Madam Josephine.
All right.
Glad
Mediator Josephine.
Yes.
Yes. I didn't hear a lot of the opening statement. I want you to go back to prepare them very well. Use your checklist. So you welcome them. You have introduced yourself. You did not talk about your center, what you are able to do. I did not hear your role that you are going to play. I did not hear the role of the parties before you, what they are expected to do at this meeting. I did not hear you talking about confidentiality. I did not hear you talk about authority, whether they have authority to take decisions on this matter. I did not hear you talk about caucusing, educating them about caucusing and the possibility of going on caucusing. I did not hear you talk about the rules, ground rules for the process. I did not hear you telling them of their rights as parties, and the fact that mediation is voluntary and that they could walk away if they so wish, but encouraging them to see to the end of the process. I didn't hear you do all that, so can you do it? Before they giving you the authority, signing the consent to mediate before they tell you their story. Can you go through with them for me? Thank you.
Okay, fine. Okay, good morning, everyone. And thank you, Sarah, Tom, and Lisa, for coming in today into this particular session where you all have agreed to. This center here, it is a peace resolution center, and we support families, individual citizens around conflicts or areas of contentions they may experience within their course of lives, just like your case now. And I want to have you know that you are welcome here, and you should feel comfortable at all times. My name is Josephine Mirembe. I am the proprietor of the Peace Resolution Center. And for this particular case, I will be your designated mediator. And I wish to welcome you to this center once again. Before I continue as a mediator, I have a form here that I would like you to all sign and consent that you allow me to oversee the resolution of the case at hand, and which involves all of you. Is it okay that I continue as your mediator?
Yes, please.
Thank you for allowing me to go on with this mediation. And Tom, are you willing for me to serve as your mediator?
I agree.
Thank you. And as we proceed, I would like you to let me know the names you are comfortable using while we process this issue. Is it okay, Sarah, if I called you Sarah?
Yes, madam.
Lisa, is it okay if I called you Lisa?
Yes, please.
And Tom, are you comfortable with me calling you Tom?
Sure, you can call me Tom.
Fine. Thank you for confirming the names I will use. And for me, you call me Josephine. As you're all aware, you have a right to raise your opinion. You have a right to be heard. And all opinions you share here are valid. All we have to do is respect each other's opinions. The ground rules here for this session that I wish to put forward are that we shall give each one of you time to share their concerns. We shall listen without confrontation to each one of your opinions. And should you please have anything you need to interrupt at the middle of the session, feel free to raise your hand, and with consent from whoever will be speaking at the time, we should be able to allow you some time to intervene. Is that okay with everyone? Sarah, Lisa, and Tom? Is that okay with you? Are we okay with the ground rules?
Fine, it's okay.
Fine, thank you. And thank you for also signing the consent form. So for now, I would like us to move into the issue at hand. And Sarah, your sister, came to me and shared the issue you had around the wealth that your family wealth and how you would want it shared amongst you. So to start us off, I would request Sarah to clearly state her stand before both of you so that we are able to also hear your sentiments regarding what Sarah will have raised. Sarah, please take up the floor.
Thank you, mediator, for this opportunity granted me. We lost our parents 10th May 2015. And as elder, I've decided to take care of my siblings since our parents left us. Their school fees, their feeding, I try to let ends meet. Just to realize of late, Tom and Lisa are planning to sell some of the family properties, which I am not in agreement. That's all. Thank you.
Thank you, Sarah, for sharing that bit of the story. And I wish to have Tom confirm whether they are planning to sell their house. Tom, are you planning to sell your family home?
Thank you, Mediator Josephine. First of all, the situation has been difficult for all of us. Losing our parents is already emotionally painful. And now we are struggling to agree on what should happen about the state. And it's not, I'm not comfortable to be in conflict permanently, with Sarah and Lisa, that would damage our relationship. And from my perspective, the practical solution is to sell the family house and divide the proceeds equally. Though Sarah has emotional attachment to the house, which all of us have because we grew up there, and but we have to keep in mind that the house is also a financial asset, and it cannot be carried out by one person unless the others also participate financially. So for me, yes, I agree that we sell the house, and that is my point of view, and that will allow us to move forward, and there will not be a disagreement between us. Yeah, I'm done.
Okay, thank you, Tom, for your sentiments. I will now call upon Lisa to confirm whether she is also supporting the selling of the house.
Thank you for this opportunity. Yes, I'm also in support of selling the house. As we know, the properties include a house, some valuable art piece, and then a sum of money. So since we are three, even though Sarah has and some emotional attachment, we all do have emotional attachment. In as much as we have emotional attachment to the house, we also do have some childhood traumas, which some of us do not want to relieve by staying in the house. And I believe we've also outgrown the space. That is, if we are to divide property, I believe somebody can take the house, which cannot be evaluated equally to the piece or the art pieces. In that case, I believe we should sell the house, evaluate the art pieces, liquidate it into cash, and then add the sum of money so we can divide them appropriately. Thank you.
Okay, I have a question for all of you. Who stays in the house currently? Is there anybody staying in the house? And who is helping
It's a family.
maintain?
Oh,
Who is currently living in that particular house?
Madam Mediator, hello.
Yes.
It's a family house. As far as we travel, we all come back to use that space. So it's a traditional home for the three of us currently. There's no one at home.
And is it the only home you own, or your parents had set up other homes?
That is the only home we have. It's a traditional home. As much as we travel out, we return to this particular home.
Okay. Okay, then do you support each other in maintaining the home? Probably paying a worker in the home, taking care of the bills. Who handles all that? Is it a collaborative effort, or there's only one of you who tends to be responsible for the home?
I am responsible as an elderly sister.
Mm-hmm. Okay. Now, if I get back to Tom and Lisa, you might be settled elsewhere now, but we have to look at life holistically. Things happen, tables turn, and usually the only place we have to rush to is home, the home of our parents. Now, Tom and Lisa, if we sold off what is the only core bond between you and what seems to be a safety net for all of you, where do you go? Where will you call home? Is it your house, Tom? Is it your house, Lisa? Or will it be Sarah's home? Where would you call home? Where each one
I
of
think
you is
mediator,
free
we
to
have.
interact?
Hello.
Yes.
Yes, I think the mediator, we have to stop you from here because now you are getting yourself involved in the matter based on the question that you are asking. Madam Anas, are you there?
Yes, I am there. But you see, we are trying to get the
I'm
basis
here.
for you to
Yes,
either
yes. You are
retain
trying
the
to get
home.
the best, but as a
Yes.
mediator, it's not everything that you get yourself involved. So as we discuss, so if you follow the process that we discuss, so you know that after the parties have made their statement, you summarize
Mm-hmm.
their each party's statement. So what did uh, Sarah said? What did Lisa said? What did Tom said? After that,
Mm-hmm.
are you able to create an agenda from what they said? Now, what will be the agenda for
Yes.
the discussion now? Now, the one thing on the agenda is that maybe the relationship, maybe family relationship, maybe how to repair certain family broken relationship. Two, issues about maybe selling of the house, the family house, and maybe other matters. So you find out from them. Listening to the three of you, I realize that there is an issue between maybe concerning your relationship that you have to deal with. Is that right? Issues concerning the whether to sell or not to sell the house. Is that right? Then this is where you come to discuss if they agree. So starting from in no particular order, you can start from repairing the relationship. Sometimes if you listen to the discussion that we did in mediation, particularly on transformative mediation, if you are able to repair the relationship can be as a basis for the resolution of the particular matter. So
Matter.
you look at that. Then after that, then you move on to the next agenda. Based on the agenda, you now can get options for resolution. So they will be bringing you alternative, what they think is the solutions, but you don't find out from them whether this is the home or that is not the home. Because if they want to sell the house, one person can raise that maybe this is a home that we all want to keep for our parents. So you find out, that person elaborate why he thinks that maybe he wants to keep the home. The person can explain. Then you find out from the other person what do they think about what this person is saying. That is the discussion stage. So with you asking them the question whether there is home or whoever stays there, if you are not careful, it will be like the mediator getting involved in the matter. Let the people bring out the issues. So and there's also a question that you ask them after they are finished speaking. Once the Sarah's finished speaking, you don't ask the people to find out from them. Let me find out from you whether you are selling the house. No, that will be like they are giving a reply to what Sarah said. So, for instance, can I hear your side of the story? So, Lisa and Tom, can I hear your side of the story? Lisa and Tom will be able to also come up with their side of the story and what they think should be the solution. So that it won't be like you, the mediator, telling them about the issue. Because Sarah has said that maybe the selling of the house and all that, but your focus is not about whether the family sell the house or not, but this is about they coming together and agreeing on what they want to do going forward. And that should be your focus. I hope you understand that.
We are learning.
Okay. Madam
Yes,
Anas, please take over.
yes, yes. I'd wanted Madam Mediator to land to finish, then probably we'll go back and talk about all that. Um, where the where she, it's like she knows so much about the story already, and if you are not careful, Tom and Lisa would think that when Sarah brought the issue, she gave you all these things, and so just like Mr. Asari is saying, you are asking them after signing the consent to mediate. Your question will be, tell us your side of the issue. You
So,
don't even say talk about house or what. You pretend you don't even know what is at stake. So you tell us about your issue. Sarah will give her background, what she knows. Tom will do the same, and then Lisa will do same. But just after Sarah's narration, you went straight to Tom to
question.
find out. To find out, is it true you want the place sold and all that? No. So the first instance, you ask them to tell you their side of the story. So then you are out of the case. So they will give you the narration. Now, after the narration, which everybody will give his or her part, then you want to bring out the issues, like Mr. Asari said. Unfortunately, for this case, the issues are even laid down for us. And so, as a mediator, you ask for confirmation from the stories they have told you, ask for confirmation. And so we see that we have three agenda or issues here for discussion. Their relationship as family, the valuation of the art pieces, and then the selling or not selling of the house. Okay, so let's take it from there. Let's say that you have the agenda. Let's negotiate, do the negotiation, and let's take it from there. Thank you.
Okay, fine. We are learning. We take the direction. I think from what you all have been able to share, I can tell that there is an issue around relationships. And I would like to encourage all of you.
So, mediator, put it this way. Ask them what they seek from the meeting. At the end of this
Okay.
meeting, what do they want? What do they seek? Ask each of them and let them tell you. Whilst they are telling you, write it down.
Mm. Okay. From the side of your story you've been able to share, I would like to know what you wish to be the resolution for this meeting. What do you think will be the best for all of you? So at this juncture, I would wish to hear your sentiments. Sarah, could we start with you?
Hello.
Yes.
Yeah, like I said earlier on, it's good we keep the home as a traditional home so that as we even travel and come, that will be our union meeting place to reflect our family settings. Thank you.
Tom, what do you wish to be the outcome of this session?
Okay, thank you, Mediator. What I hope first, sometimes I feel misunderstood uh, on my position when I'm trying to find a solution that is equitable for everyone. So for me, I hope today we have respect. We do respect the emotional attachment that we all have to our parents' legacy. Also, we have a fair financial distribution because it's not only the estate. And uh, and the last one that we preserve our relationship, our relationship as sibling, instead of getting divided over inheritance issue. So that's my expectation for today.
Okay. Lisa, what do you consider as your desired outcome of this particular session?
I'm hoping for a fair outcome at the end of the day. The house being sold, the art pieces are being liquidated for to add to the money. We have a fair share of the total money. Yes, please. That's what I'm hoping for.
Okay, so from this particular discussion, I gather that one, you are still keen on having all of you run a very healthy relationship. And two, following your sentiments, it is all in the good for everyone. Every decision here, or sentiments you have shared, is in the best interest
Madam
of
Mediator,
everyone else.
Madam Mediator,
Yes.
sorry to cut you. So let's move the discussion forward. You see,
Yes.
move the discussion forward. Now, Sarah wants the place as a family house. The others two want to sell and
Sell.
share. So, ask Tom and Lisa to share their reason for wanting the place sold. Sarah has told them already that she wants to preserve the house so that it becomes a family house where they will come back to it as a family and be together. Why is Tom and Lisa? So find out from them. Let them talk to Sarah their reason for selling the house. So probably Sarah will understand them if they share their reason for selling the house. Do you get it? And then we can move forward. Or probably after telling Sarah why they want to sell the place, Sarah will appreciate it and say that, okay, if it's money you need, probably I can also support you here and there so that we maintain the house. And then they may accept it. So let's take it from that angle.
Okay, Tom and Lisa, you intend to sell, you would love this house to be sold. Could you let us know the reasons why you want the house sold so that your sister Sarah can probably have a clear understanding of that decision to sell? Lisa, could you please share your reasons for selling the house?
Personally, I do have some emotional traumas attached to the house that I do not want to always, if the house is being kept, at the end of the day, had it been that there's any family issue, they will say, oh, your family house is here. We are all meeting in their house, your parents' house. That means I would have to go back there. I do not want to go back to the house. I don't want to have the house in existence relating to me that I have to come back there. At the end of the day, if the house is in existence and still attached to the family, I'll have to go back home regardless of anything. And I have some memories that I do not want to remember. So I insist that I want the house to be sold. Thank you.
Thank you, Lisa, for that very honest response. And now I would call upon Mr. Tom to also give us a reason to why he wants the house sold.
Thank you for asking. I think my position is not about rejecting a family home, neither dismissing the emotional value. I understand what the house is. The house represents for all of us. It's about our childhood, our parents, memories. But for me, I want the house to be sold for many reasons. First, the house is a high value asset, and it's difficult. It will be difficult for only one of us to keep it. I have my house, I have my family, and it means if we keep the house, we have to contribute. It will be, let's say like if Sarah keeps the house, it will be very difficult for her to financially to keep the house, and you have to contribute again. And also it can be a source of conflict permanently, about the cost, about
shared.
Pardon?
Oh, you are still talking?
Yes.
Okay.
I was saying that.
Okay.
I was saying that. Secondly, if we keep it, and it can also be source of permanent conflict. Because it's not easy to agree on things like repairing, like decision that on the property, how to maybe renovation, other things. It won't be easy to have a common agreement or how to keep the house. And selling the house, for me, the last reason is that selling the house will give each of us flexibility. We share according to our own needs. either we can invest or building something new, and it to be give us independence rather than continue sharing responsibility over over the house, and that will maybe complicated and be source of conflict. So that's why that are the reason that I want the house to be sold. But again, I am open to discussion and about an alternative way to have solution. I think that's why we are here today. And if Sarah truly want to keep it, we could explore, other plan to see how we can manage. Yeah. So I'm open. Thank you. That's my point.
Okay, thank you very much, Mr. Tim. Now, I get back to you, Miss Sarah. You've had Tom and Lisa share their reasons to why they want to sell the house. You've listened to them. Share your thinking around the results they have given.
Okay, thank you, mediator. I think for them having reasons not to have any reconnection to the family home, maybe they could leave it in my possession whilst we rent some of the apartments they may need. It can also be source of income for them whilst I keep the other side. Or the other option is, how much money would they need to do one or two things they think if we sell will benefit them? Maybe they could bring the amount they need to solve their issues. Or again, renting it part of the other side and not totally selling it. Thank you.
Okay, thank you, Sarah, for giving us the options you have given. And now back to Tom and Lisa. Would you be in agreement with that offer Sarah has given? Tom and Lisa, would you be in agreement with the offer Sarah has given?
Yes, I think I can consider working around with the fact that she wants to maintain a side of the house and rent out the other side of the house, which at the end of the day still bring in an income.
Okay, so Lisa here is in agreement with you, Sarah, in retaining part of the house and leasing out the other portion. What about you, Tom?
Yes, yes. As I said, I think I'm open to any alternative way to solve the issue, and if the goal is not to lose the house and ensure that whatever we decide is fair to all concerned, I think yes, that will be considered like a solution, and I think so far it will not damage our relationship as sibling in the long term. So yeah, we can consider this solution too. Yeah, why not?
Okay, so thank you all for helping out in resolving this matter. And what has come out from this discussion is that Lisa and Tom retain parts of the home, and together you still can lease out the rest of the estate and earn something from it. Is that what you would consider as a resolution for this meeting?
Yes, mediator.
Fine. Tom, are you in agreement?
Yes, but we have to have a clear how do you say agreement, if I can say that, though it's not a business matter, but I think we have to have a common comprehensive situation to know how we are going to do it and who will do what and whatever. So I don't mind. We can go ahead with that solution.
Fine. Thank you. And it is a good thing that you can see you have you have advised that you consider a legal approach to this particular agreement, which is a very wise decision, and I would encourage you to do so. So for now, I trust that you will retain your good relationship. You'll be able to have Sarah retain part of the home, and together you lease out the rest of the estate for your own benefit. Otherwise, thank you so much, and I'm happy we've been able to come to a conclusion of this meeting. And
Madam Mediator,
yes,
can I come in?
yes, come in. We are learning, don't worry.
Yes, please. Having agreed to retain some of the house, I did mention that I want the other art pieces to be evaluated and then added to the money and shared among us. I've not heard about that. What's my other siblings are
Okay.
saying about that?
Okay, from what you have said there, your family owns some art pieces. Tom and Ritsara, would you be willing to have the art pieces sold as per Lisa's statement?
Yeah, that's okay. It can be sold because
What
it has
about
value
you,
of
Tom?
money.
What about you, Tom? Would you like the art pieces that belong to your family sold out, and you share out the money?
Yeah, sorry. Yeah, yes. I think that will be the best way. And since we have also some money that will be distributed, so I think that's the best way to solve it. Yeah, thank you.
Okay, thank you so much. So from this meeting, we have 3 resolutions. Resolution number 1 is that Sarah, your elder sister, retains part of your family home. The second resolution is that you lease out the rest of the house or estate as an investment that will be bringing you in some earnings. Then the third resolution here is that you are all in agreement that the artifacts that were owned by family can be sold out for the benefit of the three of you. You'll be able to share the money that you earn from selling those artifacts. And finally, the other resolution is that you seek a legal agreement stipulating all the resolutions so that you live in harmony with an understanding that you agreed on what needs to be done around your family house. Is that right, Lisa, Tom, and Sarah?
Yes, please. But you did not
Yes.
mention the actual money that was part of the inheritance.
Okay. As from our discussion, no specific figure has been offered, but probably Tom and Lisa will be able to shed some light on the money.
All right. Madam Mediator, thank you very
Yes.
much. Thank you very much for the good work done. It's not an easy task, right?
It is not easy.
Yeah, but you have done well. You have done
Thank you.
well. Okay.
Thank
So
thank you.
before we, I want to have comments, few comments, and then we'll look at what we have agreed on. So like Tom was asking for details. When you say some part of the house to be rented, which part? It's too vague. Which part? We need to be specific. And the part to be rented, how many rooms are we renting? How is the money going to be shared? Okay, since Sarah is keeping a portion of it, maybe one room, let's say it's a 3-bedroom house. Sarah is keeping one room, and then the 2 bedrooms will be rented out. So then, if Sarah is staying in one, is she also going to benefit from what is going to be rented out? Those details are very important, and you are going to use it to write your terms of settlement. Now, the art pieces that are going to be sold, you need a valuer to look at it and how much the proceeds that is going to come out of it. And so what will be the ratio for sharing is also very important. And yes, she also, there was this money, sum of money. We can give it, let's say, 1,000, oh no, 100,000 Ghana cedis or something. And then what will be the ratio for sharing is very important. And the last one is for them to live as siblings in harmony and all that. Good. So let's hear comments, and then we put our agreement into terms of settlement and write it out quickly. Any comments, please? From the house. Maybe Tom. Tom, let's start with you. What's your impression? Any comment? Hey, did I say Tom? Right, Tom, go ahead. Hello.
Hello.
Yes, please go
Um,
ahead. What? Yes. What was done right? What could have been better?
um, um, I'm still thinking and
I'm still thinking
gather
about it. Okay. Christy.
about it.
Christy, let's hear you, Eliza.
Okay. Okay, so I think we are all learning, so
Of
she
course.
did very well. And then there was the instance when you and Saize came in, where I was about to come in when you guys came because I realized she was trying to take Sarah's side. Meanwhile, she assured us of neutrality. So that is what I observed, that at every point you should make sure that your words come out right. Not seems like you're taking somebody's side or you know already how the whole issue is all about. Yeah, thank you.
Thank you. Yes. Gloria. Oh, you dropped dog. Reverend Doctor. You are Sarah. Oh.
Yes, mommy.
Yes, go ahead.
Yes,
What?
mommy.
Let's hear your comments.
Actually, I was expecting it to be saved, but I think you've spoken that part. So thank.
Come again. I didn't hear you.
Okay, I'm saying that I was thinking when she asked me about after listening to Tom and Lisa, their mind about keeping the apartment and leasing some. How were the apartment going to be? Which apartment was I going to occupy, and how many was I releasing to them? And will I give exact money to them? But I think she asked me that part, and you came in. That's okay.
Right. Good. Yes, let's hear you. Who else? Josephine. Any comments? Mediator Josephine, any comments?
I think from your guidance, we also need to ensure specificity of issues. Like you see, especially when properties, we should be able to specify what property, any other issues around, what are the conversations around that aim for this. Those are things that we really need to be clear about, and of course not veering off the main checklist on how we need to approach the whole the mediators limits, and don't look like you want to dig into the lives of the subjects of the mediation.
Right.
Yes.
Right. So I see a new name. Thank you, mediator. Kwesi Yuenchi Boateng. Did you hear enough to comment? Hello?
Hello?
Yes. Gloria, go ahead. Is there something you wanted to say, Gloria? Please go ahead.
No, not at the moment.
Yeah. Okay, no question. Any question from anyone? Any question?
Yes, a question, madam.
Please go ahead.
Yes. Getting consensus about the agreement, how properties should be fairly distributed. At that point, can you adjourn the mediation to another date to be informing them to verify some of the price valuation in order to be able to brief them before resolution? Can that be possible?
Yes, that
Okay.
can be possible, especially when you are not too sure of the value of an item. That is one. And then two, when you think that a sitting has exceeded the time limits or the time allocated for that sitting, you can also reschedule. But the danger here is that when you reschedule a meeting, parties are going to discuss issues with other people, and if you are not careful, at your next meeting, they will come in with new uh, 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 positions, and it will be difficult for you to get a resolution. And so the advice is that if you realize you are close to a resolution, and even your time, the time allocated, is far spent, ask for their indulgence to continue to resolution and to write the terms of settlement, so that there will not be any change of mind. As we sleep and we wake up, we have change of mind all the time. That is one. But two, if there's a need for an expert advice on any issue, then definitely yes, you can adjourn to another date where those information are sorted, and so it will inform your terms of settlement to be written well. So yes, it's possible. Any other question before we go ahead to write our terms of settlement? Any other question?
A follow-up question, Mama.
Please go ahead.
Maybe the complainant that will bring the issue to you regarding property sharing too, can you please also make some background checks before meeting them for the first time?
What do
Background
you
check as to
intend?
what?
What do you
Sorry.
intend to? What do you intend to? What do you intend to find out? What
This
would
is
be
a
your
situation
mission?
to Tom and Lisa. Their other two siblings are claiming that they should share the properties equally. So maybe to know what exactly these properties entails,
Mr. Asai, were you trying to
what
answer it?
knowledge do you have?
I think you are not. One thing that we have to also remember is that in
Mm-hmm.
mediation, you are not there as a fact finding committee.
Mm-hmm.
You are there to assist the parties to talk about what they want to resolve, not what you want them to resolve. So the thing is, if you remove yourself from the issue and you let the parties drive the discussion, you will not need to go and do somebody's background. You are not a security agency, you are not the police, you are not a fact-finding committee to go and do an investigation about the issue and come out with a solution. That is why in mediation, matters which concern expert advice, you discuss with the parties and bring in an expert. For instance, if they have to share the property and they want to know the value, or even they want to sell, the parties can decide that we don't know how much we want to sell. So then you find out, are you open to we inviting a valuer for you, or do you know a valuer who can do that job? They can say that the mediator should help them to get a valuer. Then you discuss with them, then you call the valuer, then the valuer discusses their fees with them. The valuer will go and now value the property and bring a report to the mediation. Then you read the report in front of all of them to know the property, the value of their property, and even if one party elects. So because this case can go either way, in mediation, this case can be several mediation, it can be same matter in several mediation cases, and it can end in different way. It can end where Sarah can elect to buy the other siblings off so that the property can be hers. They can also decide that they will share the property and the other party will sell their part. They can decide as they have agreed that maybe they will maintain part and sell some of the artifact and all that. These are agreement parties can bring up. You don't need to go and investigate people to know their background. That is not your work as a mediator. Have you seen a judge going into anybody's home or background to investigate about even the criminal that they have brought them behind? No. They are only brought, the judge listens to them, and it based on the what the police are saying and the report that they have brought. The police are the expert to do the investigation and bring the report. And based on that, the judge will make a determination. A mediator is not a judge. Even a judge will not do that. How much more a mediator who is not a judge, who only facilitates communicating between parties. That's the most important thing. That's why from the beginning, if you have find out from the parties and they know that yes, they have authority to settle, and even you can even ask further whether when the parents died, have they done letters of administration to know that this property can now be shared or it can even be sold? Have they done it? If you are able to do all these initial things, if they have not done letters of administration, then at the end of the mediation, they know that they need to even do letters of administration before they can even share a property of a deceased person. These are some of the things that the mediation can bring out so that at the end of the day, the parties know what they want to do going forward, but not to go and investigate them, no, or to know their background. No, that is not your work.
Right. Thank you very much. So,
You President.
yes, yes. So, Reverend, with mediation, it is what parties bring to the table. That is what you are facilitating. Yours is helping them to come to an agreement, creating options and giving suggestions. As a mediator, you ask questions that brings a reality to the parties, and then they have informed decision, and then they decide what they want to do. A hand is up. We see Yuenchi. Please go ahead.
Okay, thanks very much. My apologies for joining this late. In fact, I was also handling a similar thing at my family level, trying to see how we could go about this letters of administration and then things from the family side. That's what caught my, I mean, that's what I was doing, liaising with the parties in the whole issue. That's how come I came in late today. But thanks very much. I'm just curious about the emotional tensions, and then how resolve issues from childhood. How the mediator managed to get through this nuance with the role play.
Right, right. With the role play, we did not go into details. Mediator did not go into details, but in real situation, the mediator could ask the one who raised that issue, I think Lisa did, if she is willing to share what that childhood trauma is. If she's willing to share, that is fine. If she's not willing to share, then there's not much you can do. If possible, you can take them to caucusing. If the party is willing to share in caucusing, that is fine. It will inform you, the mediator, what to do and how to navigate the whole incident. But if parties are willing to share, that is most helpful. But some
Yes,
of these things, yes.
yeah, so adding to what you have said, so one thing that we have to also understand is that when it comes to this relationship matters, sometimes even in mediation, you have to deal with that issue even before you go into other matters like the selling of the property. Because some people may decide to let us sell the property because they don't want to have any attachment with the other sisters, because what brings us together is the property that our family have left for us. So if we sell the property and there is nothing uh, between us, then we don't have any connection. So that is why they want to do that. But if you are able to resolve the relationship issue, you have been able to transform the conflict situation. And when you transform the conflict situation, you are likely to get the people saying that, yes, we even one person may even mention that we wanted to even sell the property because we didn't have a good family relation. Now that our relationship is better, we want to even keep the family property. These are some of the things that when it comes to family, especially family dispute, you have to be looking out for. Not always about the issue that the parties have brought. Sometimes you go deeper. That is why you were taught conflict analysis. So you go deeper into understanding what might have brought this issue of selling, because there may be underlying issue where people feel that if they don't take care, even someone may even benefit from the property than them. Maybe it has occurred before. So once somebody has raised that issue, that is why it is important that when the parties finish talking from the beginning, you create an agenda for discussion. So creating your agenda, mixing the two summaries, you get an agenda, and this will help you to enable the party to unearth all the issues. For instance, if you were able to bring out maybe what as an agenda to say that addressing the family issue or the emotional concern, or let me talk about the relationship issue. So talking about the relationship, you know that starting from this agenda in no particular order, maybe Lisa, in your talking, you mentioned maybe relationship issue, or Tom, you mentioned this, or Sarah, you mentioned this. Can you elaborate on that? Then the person will now explain. Once the person explains, then you can even ask further, share with your siblings what this issue, how this issue has affected you, and the impact it has had on you, and what you intend to see from this discussion today. Then these people will now come out and share. Then they will also bring their part of it. And at the end of the day, you will see that the lost family ties or the family relationships are being repaired. And if they are able to repair, it will be as a basis for the eventual resolution of the matters. So that is what I want to add. Thank you.
Yes, thank you very much. Yes, and exactly so. You see, it became difficult for in this case because um the parties did not talk much. When you allow a party to talk, for instance, when Tom was we asked Tom why he wants the property sold. He said something to the effect that, if I remember correctly, the fact that um, when the property is there, they will have to come together to maintain it. They will have to relate in a way. It's going to be a burden on him and all that. And then Lisa also said because of her trauma from the beginning and all that. And so as a mediator, you pick on those words. So when you say trauma, what do you mean? Do you want to share? And so then you allow them to talk, to express themselves, and then you pick these key things, and then you discuss it, and then you see solutions for them. And so it's important that parties are allowed to talk. Let them talk. As they talk, you pick all those signals, and then you ask more probing questions, and they will come out with everything that is bothering them. All right. On this note, I'm sure our time is fast spent. And so, on this note, let's try to write our terms of settlement, maybe 5 minutes. I'll give 5 minutes to us, and then we sample our terms of settlement and we read it out. And so you have your terms of settlement form, you have the name of the letterhead or form head, the name of your center, you have the case number, you have the date, you have the portion for who is a claimant, who is a respondent, and all that. So start with your introduction to the terms, the agreement, and then we are looking at 4 issues. One, but in your writing, I want you to be specific, detailed. One is on the building. One is on the family house. Which portion is to be sold? Name it. So maybe 1 room to be rented out or 2 rooms to be rented out. The amount, how should it be shared? Who are taking what? And then the second agenda is the selling of the art pieces. So which who is doing the selling? When is it supposed to be done? The proceeds, who or how is it going to be shared? You give quotations to that as well. And then the third one is the amount of money that is part of the property left. How is it to be shared? So let's share it equally. So attribute portion ratio to it. And then the last one is parties living in harmony, and amicable solution to this issue. So in the next 5 minutes, each person should write their settlement. So it's 3:49 by my time. Let's give 5 minutes. Let's see what you come up with. Thank you. So start work. I hope the instruction is clear.
Yes, please.
All right. Okay, so 5 minutes. Go ahead.
Oops. Sorry, I lost you a little bit, and I know there was an instruction. I didn't get it fully.
Is it Kanye? Hello? Someone was
Hello.
talking. Yes.
Yes,
So the
it was.
the facilitator has given work to everyone. Use the case study, assuming you have a solution. So write an outcome for it. Write the terms of settlement for it. So he has given everyone five minutes to do that.
Okay.
Right. Okay. I'm sure we have done something. And so let's start with the preamble. Kristen, read your preamble. And then Gloria, you read your first point, and then Josephine the second, Kayi the third, Kwesi the fourth, and then Reverend. We also will hear your fourth. Okay, in that order. So, Kristen, go ahead. What was your preamble? Kristen, read your preamble to us. Hello. Is Kristen here or she dropped? Or anybody to read the preamble? When you read your preamble, you are safe. Another person will read the first point. So someone to read the preamble. We have 4 minutes to end the session, please. Hello, can you hear me? Mr. Asari, is everybody here? Or we have closed?
No, they are all here. I don't know why they are not talking.
Sorry, I went
Yeah,
over
hearing.
there.
All right. Mr. Asari, I'm sure you are meeting tomorrow, right? Mr. Asari?
Yes, madam. We are
Yes,
meeting tomorrow.
tomorrow morning. Yes, tomorrow morning.
Okay, so that will be our assignment. Let's give it as an assignment so we
Okay.
can close.
No,
Okay.
please, we are continuing.
So we'll do it. Okay, so the time is even up. So we are
Yes,
closing for today. Then
yes.
tomorrow morning
Oh,
we
our
can
outcomes,
Okay.
our outcomes agreements
Take
as
your time
one,
and
as
write
part
it
of
well. Take your time and write it well. So everybody will post theirs tomorrow and we'll analyze it. Okay.
okay,
Right.
okay.
Thank you. Thank you, Mr. Asari.
Okay,
Over
thank you,
to you.
Madam Anas, for joining us. It's been a pleasure having you. And thank you all for also joining.
Same here.
Tomorrow will be the first day. Please let us endeavor to come on time, 9:30 a.m. We start, then we see what we can do for the day. So on that note, thank you all. And please do have a good evening. We'll see you tomorrow.
Are we going to have